Welcome to the Thursday, December 12th, 2024 agenda meeting of the Minnesota Public Utilities Commission. I'm Katie Sieben, the chair of the commission. I'll take the role now of the other commissioners who are present for today's hearing. Commissioner Means. Here. Commissioner Hom.
Here.
Commissioner Sullivan.
Here.
Commissioner Tuma.
Here.
A quorum is present. We have 4 items on our agenda today. The 4th item won't start before 12:30 p.m. So we'll begin with docket number 1, or the first item on our agenda today. It's not docket number 1, but Mr. Noyce, will you please introduce the docket for us?
Of course. Good morning, Chair Sieben and Commissioners. Item number 1 is docket number E002,111/SA-24-347, involving Northern States Power Company doing business as Xcel Energy and Dakota Electric Association. In the matter of the request of a compensation and orderly transfer agreement between Xcel Energy and Dakota Electric Association, the question before the commission is, should the commission approve the service territory transfer? We have representatives from the Department of Commerce, Xcel Energy, and Dakota Electric. Staff have no additional comment.
Thank you. Commissioner Tuma.
Yeah, Madam Chair, I reviewed it. Everything looks as it should be. And I did drive by it, but that's only because it's on my back road up to Apple Valley when we're going up to shop up in Apple Valley from where I live. So I would move that we approve the joint request of Xcel and Dakota Electric Cooperative and request that Mingeo update the service territory map to reflect the changes on the map as provided.
Is there any discussion of Commissioner Tuma's motion? Hearing none, all in favor, please say aye.
Aye.
Aye. Opposed, the motion prevails. And next, item number 2, please.
Item number 2 is docket number E002,257-SA-24-348, involving Northern States Power Company doing business as Xcel Energy and the City of Kasson. In the matter of the request of a compensation and orderly transfer agreement between Xcel Energy and the City of Kasson, the question before the commission is, should the commission approve the requested service area transfer? We have representatives from the Department of Commerce, Xcel Energy, and the City available for commissioner questions. Staff have no additional comment.
Great, thank you. And Commissioner Tuma.
Again, Madam Chair, everything looks pretty good. This is a standard municipal expansion, and so I think it looks just fine. Notice was given appropriately, so I would move that the joint request of Xcel and the City of Kasson be adopted, and we request that Mingeo update the service territory map to reflect the changes on the maps provided.
Great, thank you, Commissioner Tuma. Is there any discussion of his motion? Hearing none, all in favor, please say aye.
Aye.
Aye. Opposed, the motion prevails. Thank you very much to the parties for those 2 items. Next, we'll move to agenda item number 3. If the parties who are speaking want to come forward, now we will have the docket introduced and then move to opening comments from intervening parties. And for those of you who, if there isn't enough room or there's another microphone over there, we can shift around too, so that there's a microphone over there if you want to go over there, Mr. Levi. Oh, you want to be together?
Or we want to stay together.
Stay together. Mr. Janicek, good morning. Please introduce item number 3 when you're ready.
Good morning, Chair Sieben and Commissioners. Item number 3 is docket number 22422 in the matter of the applicant of Subic Carbon Solutions LLC for a routing permit for the Otter Tail to Wilkin County carbon dioxide pipeline project. The questions before the commission are, should the final environmental impact statement be found to be adequate? Should Summit be granted a route permit for its proposed CO2 pipeline project? If a routing permit is granted, which route alternative should be selected? If Summit is granted a routing permit, what permit conditions are appropriate? Staff has one correction regarding the decision options. Item number 7 is supported by Cure only. Thank you.
Thank you very much, Mr. Janasick. And an email was sent or a notice of opening comments, and opening comments will be, first we'll begin with Summit, then Cure, then Local 49, then the CEOs, and end with the Department of Commerce. So we'll begin with you, Ms. Brusvin. Good morning. Please state your appearance, and then I think we allotted about 3 minutes per party.
Good morning, Chair Sieben and Commissioners. Christy Brusvin, appearing on behalf of Summit Carbon Solutions. I'm joined by my co-counsel, Pat Malberg, and other representatives from Summit Carbon in the room today. The decision before you involves routing of an approximately 28-mile pipeline that's 4 inches in diameter and crosses largely agricultural fields. Because this is the first pipeline to transport CO2, you asked the Department of Commerce to complete an environmental impact statement for the project, and you asked an administrative law judge to preside over a full contested case hearing and prepare a full report and recommendation. With that contested case record, the FEIS, and the administrative law judge's report, you have a complete record before you answering the question of whether this project meets your routing criteria and what, if any, unique conditions are present that would require special conditions. And here's what we've learned. We've learned that the project will have a net benefit of reducing CO2 into the atmosphere, consistent with Minnesota's climate goals. We know that the project will be constructed by skilled union workforce following industry best practices and agency-recommended mitigation measures. And with these measures, we know that for all routes evaluated, the FEIS found that the impacts would be negligible, minimal, and not significant, and construction-related for the most part. We also learned that RA South is the best route when you weigh all of your criteria under 7852. The pipeline has the fewest residents within 800 feet of the line. It also has the fewest noise-sensitive receptors within 400 feet of the line. This route reflects the input of landowners who live along the right-of-way and the specific interests they have in those properties. We've also learned that RA South has been surveyed and has further provided evidence that it will minimize and avoid cultural and natural resource impacts. We've also learned that in the unlikely event of a release of CO2 from the pipeline, that the impacts will be very proximate to the pipeline, and that any CO2 released will quickly dissipate into the atmosphere. Summit is asking that you find this EIS to be adequate, that you adopt the ALJ's report, and that you issue a route permit for RA South. There are a number of reasonable conditions that were developed through testimony in the FEIS, and they're reflected in the draft route permit included with staff's briefing papers. Summit has also reviewed the additional conditions that were filed in the briefing papers that were not a part of the ALJ report. And yesterday, Summit filed some recommended changes to those decision options to better reflect the record in this case or to clarify compliance-related obligations. With the addition of Summit's proposed modification, Summit supports the following decision options. 1, 3A to I, J as modified, K, L as modified, 6, 8, 11A as modified, B, C as modified, D, the modified E and F, Commissioner Hum's H, 12 as modified, and 13 and 14. We'd also appreciate the opportunity at the appropriate time to discuss Commissioner Tuma's decision options to A and G. We really want to thank the work that the department, the PUC staff, and OAH have done on this docket, and we look forward to answering your questions.
Thank you very much, Ms. Brusvin. Next, we'll go to Commissioner Sullivan.
Just was hoping that Ms. Brusvin could just go through it one more time. I
Sure.
lost track, and then I was off the scene. So, of the decision options, yeah.
I got it. 1, 3A to I, J as modified, K, L as modified, 6, 8, 11A as modified, B, C as modified, D, modified E and F, Commissioner Ham's H, 12 as modified, and 13 and 14.
Next, we'll hear from CURE. Good morning. Please state your name for the record.
Good morning, Chair Sieben, Commissioners. My name is Sarah Meridian, and I'm here today on behalf of CURE. The project proposed by the applicant would be the first CO2 pipeline in the state of Minnesota and the first CO2 pipeline built by the applicant. It would be connected to the 2,500-mile, $8.9 billion Midwest Carbon Express that the applicant plans to build throughout 5 Midwestern states, including in 8 additional counties in southwestern and central Minnesota. Neither this project nor its potential impacts are small, minor, or insignificant, especially to those rural people who would live and work near the pipeline and to the environmental resources the project would cross and affect. The Commission has expressed a desire to get the permitting for this first-of-its-kind project right. Now is the time for the Commission to do so by finding the EIS inadequate, selecting the no-route alternative, and rejecting the applicant's application for a pipeline route permit. Doing things right sometimes requires taking enough time to do it again. While considerable time and money were spent completing the EIS, in spite of the applicant's repeated protests about costs, these factors alone do not make environmental review adequate. Environmental review must meet the requirements of the Minnesota Environmental Policy Act. Because this EIS contained incomplete, inaccurate information and consistently repeated unverified statements made by the applicant as fact, the EIS does not meet the requirements of MEPA and cannot be found adequate. And without adequate information, the Commission cannot make an informed decision on the pipeline route permit before it. If the Commission disagrees and decides the EIS is adequate, it should not issue a route permit for this pipeline because the reliable evidence that is in the record shows that only the no-action alternative will avoid the significant environmental and human health impacts that this project poses. If the Commission believes it must issue a route permit, despite a lack of evidence supporting that conclusion, it should select Route Alternative North. The EIS and testimony from CURE's expert witnesses confirms that this route poses the least amount of risk to the environment and human health during construction and operation. While some parties have characterized the differences between the routes as minimal or merely shifting the impacts elsewhere, RA North would require demonstrably fewer miles of pipeline to be built, cross fewer wetlands, surface waters, sensitive soils, acres of prime farmland, and acres of public and designated lands than RA South, and would parallel existing road rights-of-way for 96% of its length compared to just 46% of its length for RA South. Again, we ask that the Commission find the EIS inadequate, select the no-route alternative, and deny the applicant's application for a route permit. These are best represented in decision options 2, 4A through G, 5A through E, 7, and 10. But if the Commission does decide to issue a route permit, contrary to the evidence in the record, it should adopt decision options 9, 11, and 12, including Commissioners Tuma and Ham's edits to decision option 11. CURE strongly opposes the applicant's proposed amendments, which would severely weaken decision options 3, 11, and 12. Thank you. I look forward to answering any questions.
Thank you, Ms. Meridian. Next is Local 49.
Chair Sieben, Commissioners, my name is Charles Sutton. I'm here on behalf of the International Union of Operating Engineers, Local 49, a construction union representing heavy equipment operators and their families in Minnesota and the Dakotas. We also have a number of members here in the room today to show their support for the project, and I would note there's also members of the Laborers Union as well as the Carpenters and Millwrights Union here today as well. The IPCC has made clear that carbon capture and sequestration is an essential technology for achieving emissions reductions needed to meet net zero targets. The most recent IPCC working group analyzed an array of energy pathways needed to keep global warming below 1.5 or 2 degrees Celsius. They found that almost every one of those pathways required significant deployment of carbon capture and storage to achieve these targets. That's why Minnesota Senator Tina Smith authored a number of bills to expand access to the 45Q tax credit, stating that carbon capture and storage is crucial technology for reducing emissions from biofuels, steel, and other industries important to Minnesota. Recognizing the importance of CCS, the Biden administration included portions of those provisions authored by Senator Smith as part of the Inflation Reduction Act to incentivize projects just like this one to help reduce carbon emissions. Over the past few years, Governor Walz has partnered with Delta Airlines, Greater MSP, and others to make Minnesota a SAF hub and help meet the challenge of decarbonizing the aviation sector. Without CCS, it will be nearly impossible to develop and scale up that industry in Minnesota in a way that can contribute meaningfully to decarbonization of that sector. In short, CCS has a wide array of applications that will be critical for meeting the state's greenhouse gas reduction targets. But none of this can happen unless Minnesota can show that we can permit and successfully deploy projects like the Summit project. At the same time, there's a lot we don't know about the future, and today's decision does not require you to take a position on how exactly we are going to decarbonize each individual sector. Today's decision involves a 28-mile, 4-inch pipeline and the capture of transport of carbon from a single ethanol plant in Fergus Falls. If the Commission grants a route permit, the carbon from that facility will be captured and sequestered in North Dakota. If the Commission denies a route permit, that carbon will continue to be emitted into the atmosphere where it will contribute to global warming. Today's decision does not impact overall ethanol production or land use to support it. It doesn't impact the rate of EV adoption. We believe the Commission has a strong and thorough record to support the granting of the permit. As the Commission recalls, there was originally some question about whether this project would be permitted at the county level or by the Commission. The Commission correctly, in our view, recognized that they were the right authority to permit the project. While the law only required a comparative environmental analysis for the pipelines, the Commission, recognizing that this was a first-of-its-kind project, ordered a full 4410 EIS. The final EIS put together by Mr. Levi and the department is exceptionally thorough, in our view, more than adequate for a project of this size and scope. Lastly, as the Commission is aware, Local 49 represents workers who build and maintain pipeline infrastructure. And we believe it is important that those that build the infrastructure are well paid and well trained and working for experienced contractors who can get the job done in a way that protects workers, the surrounding community, and the environment. Today, we are happy to say that we are strongly supportive of this project and believe that Summit is fully committed to doing this project right. We strongly encourage the Commission to approve the project and support the decision options laid out by Ms. Brusvin with the applicant. We also do have some concerns about some of Commissioner Tuma's proposed decision options and are happy to answer any questions when the time is appropriate.
Thank you, Mr. Sutton. And Ms. Henchek.
Chair Sieben, Commissioners, thank you. My name is Abigail Henchek, and I represent the CEOs in this case, which are made up of Sierra Club and the Minnesota Center for Environmental Advocacy. The CEOs believe that the Commission has the authority to deny a route permit and should do so in this case. Despite the framing from the applicant, it's not clear from the record that this project is a climate solution. In assessing a climate solution, just like when you're assessing a climate problem, you have to look at the broader emissions related to the project. We have serious concerns that these broader emissions outweigh the amount of carbon that's captured and sequestered here. The validity of these concerns is supported by the EIS. For example, the EIS lays out both the likelihood that this project will result in land use change and the likelihood that the carbon is used for enhanced oil recovery, both of which would result in CO2 emissions that outpace that captured by the project. So it is actually possible that this project increases the greenhouse gas emissions. Once you strip away this purported climate benefit, what's left is a significant infrastructure project with no clear benefit beyond the economic benefit to the companies involved. and this benefit does not outweigh the risks. In addition to the climate risks, there are safety risks and economic risks to this project. The safety concerns are widely acknowledged in that PHMSA itself understands its regulations regarding carbon pipelines to be not robust enough to protect frontline communities. And the Commission cannot fill these safety gaps because it's preempted from acting within this space. Given the lack of adequate safety regulations, the CEOs do not believe that Minnesotans should be the test subjects for these new technologies. There are also economic risks to farmers who live along the route. We know that disturbing land and disturbing soil causes crop losses. The EIS acknowledges that these crop losses can be long-term, and this is a huge risk for farmers whose livelihoods depend on their crops and who work with very small profit margins. That said, if the Commission is inclined to grant a permit today, the CEOs believe that many of the permit conditions outlined in the briefing papers should be included. We were very excited to see the decision options proposed by staff and the commissioners, and we think that these permit conditions offer really good protections that make some solid progress towards addressing our concerns. By way of summary, the CEOs support decision options 2, 3F, 3I, 4B through D, 5A through E, and 10. If the Commission is inclined to grant the permit, we would support the following decision options. The Department's 3L, Commissioner Tuma's 11A, staff's 11B, C, E, F, 11G and H, staff's 12, 13, and 14. I'm happy to answer any questions. Thank you.
Thank you very much. Next, I think we're to the department. Is that right? Yes. Welcome. Please state your appearance for the record.
Good morning, Chair Sieben, Commissioners, Catherine Arnold, Assistant Attorney General for the Department of Commerce. With me at council table today is Andrew Levi, an Environmental Review Manager for the Department of Commerce. The department's role in this matter was limited to the preparation of an environmental impact statement, or EIS, for the proposed pipeline project. The EIS was prepared by a team of approximately 30 professionals, including outside experts, under the supervision of Mr. Levi. The preparation of the EIS took more than a year of diligent work and required the dedication of significant resources. The final EIS reflects the work that was put into it and meets all relevant requirements. It reflects good faith engagement with public commenters, state and federal technical agencies and tribal partners, and sufficiently describes the relative impacts associated with the proposed project and each reasonable alternative. As all parties except CURE recognize, the EIS addresses all relevant issues and provides a basis for informed decision-making. Acknowledging the department's efforts, the administrative law judge found the EIS demonstrates a commitment to sincere, responsive public engagement and complies with all applicable requirements. We appreciate the staff's agreement in briefing papers with the ALJ's findings, conclusions, and recommendations about the adequacy of the EIS as modified by the minor exceptions recommended by the department. We ask that the Commission find the EIS to be adequate. Our decision options are 1, 3A through K, modified 3L, and 6. We are available for any questions.
1, 3A through K, modified
3L.
3L.
And 6.
Okay, thank you. We'll go to Commissioner questions now. Who would like to begin? Commissioner Tuma.
Thank you, Madam Chair. Let's just start with number 11. I assumed that was going to be problematic, so help me understand.
Commissioner Tuma, oh, there we go. I think you have to lean into your mic a little more.
Lean in. I'll lean into this one. when, and I have no problem with your first sentence. I think your additions are fine. So we're focusing on the second half, and this is kind of staging a construction, and basically both the second half of my suggested 11 and G is about the staging question and what's going to happen. So when is the targeted starting for the construction of the sequestration in North Dakota? I know that you got a permit there, is all I know, what I read in the papers. So I'm trying to understand here today, when is your construction plan for the sequestration portion?
Madam Chair, Commissioner Tuma, the North Dakota Industrial Commission actually decides on the sequestration permit at 1:30 today.
Okay.
So I hope your prediction is correct.
Well, Randy, if you're listening, good luck. So.
But the plan for start of construction is 2026, again, pending all appropriate other permits that might be required for the project. But right now, end of 2026.
So 2026, pretty general, first quarter, second quarter, you don't know yet.
Madam Chair, Commissioner Tuma, it will just be dependent on when all of the appropriate pieces fall into place.
Okay. And will that happen first before you start the pipe in North Dakota?
I'm getting nods, Commissioner Tuma, so yes.
So they'll start construction. My assumption, though, there'll still be parallel construction.
Madam Chair, Commissioner Tuma, that's correct, yes.
And how soon after any idea how soon after you start construction with the sequestration facility you would start with the pipeline?
I'm gonna look behind me again. Give me just a second. Thank you. Chair Stephen and Commissioner Tuma, it'll be done in tandem, so the exact sequence in terms of the start will just...
We're just not here, but it's still out. It's still out of ways, 2026.
Yeah, we'll get an authorization to construct, and there'll be a sequence based on where the crews can be placed and where they're available.
Any idea where you're going to start in North Dakota?
Madam Chair and Commissioner Tuma, no, I don't think so at this point, although I do think that as it relates to this project, we're likely to be building west to east, although the crews may end up sort of meeting in the middle. The construction activity related to the capture site would be ahead of the pipeline, in Minnesota as well, assuming we're starting with the right weather conditions, because that capture facility is a longer build than the pipeline itself. So the crews will be assigned to various segments in North Dakota, and based on their progress, will come over into Minnesota as they're available.
So I kind of view this as the tail of the project, and so we don't know where you're going to start, but this is basically what I would call the east end of North Dakota, is this project. And so it doesn't seem to be the first in priority if you're going to be sequencing in North Dakota.
Madam Chair and Commissioner Tuma, I think that there'll be efforts along the main line, sort of the trunk line through North Dakota, and then these various spurs, if you will, that come off to individual plants. So I do think if all of the land and the permits are in place, that sequence, they will be largely overlapping, again, because there'll be skilled workers moving from the various different components that they're involved in along the right-of-way.
And just for timing, this gets into the timing question both for this and for 12. It seems to me that there is sufficient time for us to be looking at some of these issues and being concerned about them, because we're not talking about construction more than likely in Minnesota first quarter of 2026. It sounds like we're again the tail of the dog here, and it's not going to be a priority that's going to trip up your project. And so 2026, sometime later in 2026, is likely when they'll be doing things in Minnesota.
Madam Chair, Commissioner Tuma, the caveat to that, again, is the capture facility. I would say generally in Minnesota, you're not doing a lot of construction Q1 of any year, right? But there may be grading and other opportunities since we're, again, adjacent to the ethanol facility that can get underway. And so I agree with you that there's an opportunity to sort of look at the sequence ahead of construction. With this permit, there are a number of pre-construction filings that will be made, and so I think there will be, a good line of sight into when construction in Minnesota will start and at that point, a lot more information about when that will occur relative to the North Dakota activities.
And I'm asking these questions both for this one and for 12, the question of how do we deal with insurance and knowing insurance. This is a new animal that we're dealing with, clearly, but not. I mean, it's a pipe in the ground. Would you go forward if it's just a Minnesota North Dakota project? I do know that some of our project, if it were just a Minnesota North Dakota, the way you have it designed, they would dip down into South Dakota and have to head north. So I'm just curious if your client has made a determination if this is just a Minnesota North Dakota endeavor, South Dakota blocks you, Nebraska blocks you. Are you going forward or don't you know?
Madam Chair and Commissioner Tooma, I don't think we know the answer to that. Certainly, we want to make sure we're capturing as much carbon as we can based on the contracts that the company has. But certainly, again, we'd be looking at that in the full picture. And if the approvals aren't there to support the entirety of the project, it wouldn't be built.
Yeah, and in some ways, Iowa seems to be a pretty important part of this because I think most of your ethanol sequestering is coming from Iowa, if I understand the whole of the project at this stage.
Madam Chair, Commissioner Tooma, that's correct.
So if hypothetically you're sued by, I don't know, say the second largest county in North Dakota, and a court with due authority adjoins you from construction in North Dakota, at least in that county, what is your plans?
Ms. Brusvin.
Madam Chair and Commissioner Tooma, it would depend on what activities occurred in Minnesota at that point in time. Again, we're talking about a 4.5-inch pipe with a fairly small trench. From a landowner impact standpoint, we're going to be in and out in a single growing season, and we'd like to make sure that occurs. And same thing with our workforce, right? So that we're not leaving equipment staged and mobilizing, demobilizing, things like that. It may actually be least impactful to complete putting the pipe in the ground and at least, begin the restoration activities as we work through any legal challenges that might occur in another state. Because again, there are various components of this project that tie together. We wouldn't want sort of a small issue that might not impact the overall construction to tie up progress on other portions that still have full authorization to construct.
So if the federal tax credits go away, your friends the union mentioned those, and they seem to be an integral part of what you're doing. And I think it matters to us because if the federal tax credits go away, I'm guessing, but you can tell me otherwise, that the project doesn't become viable and Summit no longer exists. That's the way I'm sitting here looking at the record and looking at what I know so far, but I don't want to make decisions on assumptions that I don't hear from you. So help me out. If the federal tax credits go away that the unions talked about, if they go away, and the possibility, my understanding is that the first act out of the Congress that's coming is going to be border security and energy, and that they need a lot of pay-fors maybe out of energy. So there's a possibility that some tax credits could be disappearing here, even within a matter of months. If they go away, does this project go away?
Ms. Brusvin.
Madam Chair and Commissioner Tooma, the 45Q tax credits are an integral part of the business operation and plans for the project. It would definitely cause a reassessment.
There's other things that you're getting. There's the ability to sell in markets in California, but you can see it's going to cause a serious reevaluation. I hope you can see from my end, I'm concerned about a trench being left in the ground between, Wahpeton and Fergus Falls. I suppose we could maybe build a canal there and ship our corn up to the ethanol plant, but I doubt that's probably going to be viable. So my concern is that a trench is left there, and we're left with a problem and a bankrupt Summit that we can't come and find to fix the problem.
Madam
Ms.
Chair,
Brusvin.
Madam Chair and Commissioner Tooma, certainly there's a lot of potential scenarios that you've just laid out. For us, we will be making sure, right, from both a financing perspective and our approvals, that we have a viable project before we're beginning construction. And part of that is gaining permits like this so that we're showing progress and that we know what we have left to overcome and what hurdles might be in front of us.
So you didn't say you support 12, okay? You'd want to modify 12 as a staff. Basically go back to what our typical permit would be for most pipeline companies, and that is, we'll tell you what our insurance is when we do the permit. And so I'm looking at this and thinking there's some viability. I would even add, to be honest with you, to this, to 12, something along the lines of the conditions of the issuance of the route permit on the permittee. One, on the creation of a fund of a sufficient financial security instrument, and I would ask plural, instruments, to protect against the failure to complete construction and fund decommissioning. I got to imagine decommissioning is not going to be a big problem here. It's not a big pipe, and it's pretty easy to decommission. The part that I'm thinking about is when our good 49ers are out there working and we're left with a hole and we have a bankrupt company, are we going to have sufficient money to pay your guys? Because there's not going to be any mechanics liens here. Okay, you're not building a house. Okay, you're building something that unless you're pumping CO2 has no value. And then I have farmers who are mad at me because they have a bankrupt company with a hole in the ground, and I can't imagine they individually will be able to create enough protections in their lease if there is a bankrupt situation. There need to be some protections that step forward. I disagree with my environmental friends that I need to protect farmers for their loss of crops. They're smart enough to figure that out themselves. I don't need to tell them how to sign a lease because they're not forced. You're not out there telling them. Eminent domain is coming, okay? The farmer is going to be able to sign these leases free and willing, and if they don't sign it and you can't sign them up on this route, there is no pipeline, okay? So I'm trying to think of the situation where we have an empty hole in the ground, a bankrupt company, and so that's what I'm thinking here. I'll give you a chance to tell me why I'm wrong, why 12 is a problem, and why my additions to 12 would be a problem.
Madam Chair and Commissioner Tuma, I think on this you need to trust your record. So the company provided a decommissioning plan as attachment 7 to the application. It's been available since September of 2022 when we filed. The department looked at the decommissioning plan in section 2.7
Like
of
I
the
said,
FEIS.
I'm not really worried about the decommissioning plan. Go to what I'm talking about.
Sure.
And that is the hole in the ground and a bankrupt company. And so I would like to know that there are protections in our permit, which is not normal, but this is not a normal situation, that protects to make sure that the workers are paid and the hole in ground is filled in.
So again, I think from the standpoint of if the company's not going to start construction on this endeavor without a solid plan that it's going to be able to go into operations, right? There are both your permit restrictions and financing considerations that are substantial before we actually endeavor to full-scale begin construction. There are going to be lots of layers of that protection with the banks and all of the companies involved in that. And so before we start, we know we're going to be able to finish, right? That's how these big projects like this come together, is all the pieces are in place and the funding is in place to complete the project. We're also talking about a very small trench and a pipe that's 4.5 inches, 54 inches underground with nothing in it. So as long as we are filling that trench, right, and restoring, we are not talking about a big hole in the ground in any circumstance, nor are we talking about any product that proposes, has any potential impact to the surrounding community. So from all of those angles, this was not an issue contested in the case because we've got all of the systems in place, a decommissioning plan, all of those things that are set forth to make sure that the project is a go and that we are fully restoring once construction, once the project is no longer in service. The plan here is for the financial security to be provided at year 10, related decommissioning. The department's reviewed that. It was available to the public.
Again, I have no problem with that. I think that looks fine. And you're right, it was not contested. And I think that's why I think our staff's draft of let's open a docket and talk about this because of its being unusual allows it to be dealt with. It doesn't need to be contested. I don't need the ALJ to tell me how to put together financial assurance. We're still figuring that out ourselves. As you know, with a company out of North Dakota that was trying to build or take over ownership of a power line. So
my suggestion, Commissioner Tuma, if the financial security is of concern, we would move the date that the financial security is in place from year 10 to the beginning of construction, so that it's in place before we start construction. You know the decommissioning Because again, that's what we're talking about. We're talking about funds to decommission. That's what a mid-start to construction and a stop looks like. We would move that decommissioning from year 10 to year 1 if that's a concern that is a stopping point for you.
And to me, that's what I think 12 does. I mean, 12 is trying to get to what does this look like? It's not what it's in our permit normally. We need something that looks a little bit better, given this scenario. I'm hopeful it's successful. I want the construction jobs to be out there, but I do have a little bit of somewhat nervous about this company's existence. This is not an oil pipeline from an long existing company who's trying to figure out the best route to deliver oil. This is a startup company who has built their model on tax credits that are somewhat tenuous in my mind, and a California standard for fuel. And so all of that seems to be making sense. I see that. I have no problem. All that holds together, but any one of those little dominoes fall, I'm left with possibly a hole in somebody's yard, and them coming and asking, "What did you do for me?" And then I got, everybody screaming and hollering, "Why didn't you put a protection in there?" So I'm trying to be careful in this, and this 12 seems to gives me that carefulness to look at it, and it shouldn't disrupt your construction if we can get it in place.
Ms. Brusvin.
Madam Chair and Commissioner Tuma, I hear you on that. I just think that the additional and kind of prolonged proceeding on this is unnecessary if the concern is we'd like you to have financial security at the start of construction. We have a mechanism to do that today, and it avoids another what could be protracted proceeding, which I don't think is in the interest of the Commission or the parties based on what's in the record today.
So if I hear what you're saying is you're not opposed to us wanting to have some protections in place for this period of time at the beginning of construction on through construction. Your concern is the extra proceeding. So you wouldn't object to the language or the goal we're trying to accomplish here, or maybe come up with some better language, but the general goal of what we're trying to do, protect the workers, protect the landowners in case of a bankruptcy by doing some financial assurance that begins right away, but through the normal process where you would give it to us at plan and profile.
Madam Chair,
Ms.
Commissioner
Brusvin.
Tuma, as the decommissioning and that piece correct. I'd like to have a further conversation on insurance if we get to that point, but I would agree with you as to the decommissioning or the start of construction question.
Walking through this scenario, we get it, and our staff or Mr. Levi has some problems with what you give us at that stage. I want to be clear that it could come back to us. We can stop the plan and profile, and it would come back to us for consideration if there is some concerns that are raised with what you provide.
Ms. Brusvin.
Madam Chair and Commissioner Tuma, that would be my understanding of the process, that if we provided a compliance filing to the department, they don't believe it meets the requirements of your order, they would check the box that there's still a dispute and we would come back to you.
So you're okay with the concept of making sure we protect everybody from the get-go. It's a process question. We have to decide that process question, whether we want to have a more thorough comments from our CEO friends or from the union friends, which is what I think 12 lays out, versus somewhat in the normal course of activities, it's going to show up in the permit and everybody better be watching because there's not going to be a notice going out that that's there. That's my balancing right now.
Madam Chair and
Ms.
Commissioner
Brusvin.
Tuma, that's correct. And I think, again, if there had been disputes among the parties, they had an opportunity over the course of the contested case to raise that concern, which is why I don't think another proceeding is required. I think you have the tools in the record before you to address the concern you have today and for us to file through a compliance filing.
And Commissioner Tuma, this has been helpful. Did you comment on 12 or you're supportive of 12?
Chair Sieben, we only provided decision options through 6. We did not comment on later options, but we, as mentioned, the EIS did address the decommissioning. We think, given the concerns raised by Commissioner Tuma, if they're willing to move this to the start of construction, the decommissioning funding, that makes sense.
It seems like, Commissioner Tuma, one of the issues I just heard in 12 is the date or when the actual, like, issuance of this would begin. Is that correct? I'm just not moving into deliberation, but trying to listen to what you're saying, and I'm following you and supporting you on getting this language in a way that works to protect the public, if
Yeah, I think that
that's
was
the
the-
direction the commission goes.
That's exactly right, Madam Chair. If we go with the suggested modifications that Ms. Brusman did to what is in 12, would be to somewhat tie it into our normal permitting process. If we go with the way it's drafted now, 12, there's an unknown date out there how soon we can get through a new docket. And so I think that's the distinction there. And I guess it kind of falls on the department, if we do the modified approach, the normal approach would be you're under some pressure to look at that information and try to make a judgment of whether this is appropriate to protect the public. So if you're okay with that, I'm kind of okay with it too, but I guess I want to know from the department, are you willing to take on that additional work and risk? Or would you rather have it somewhat vetted in a public hearing type setting and notice and comment and that kind of stuff?
The department. And then could you also comment on sorry, I'm trying to track all the different language. So can you also comment on that, what you just heard, and then also the revised 12? Right? Is that what you just asked?
Yeah, the
Commissioner
revised 12
Tuma?
would be that additional language of during construction protections.
And if you need the language on the screen, we can do that too, I think.
Yeah, I think Ms. Fazio has the language. Yeah.
Oh, except we don't have a screen. Well, that one doesn't work. I don't know if.
So much paper. Madam Chair, Commissioner Tuma, while we're waiting for the language to come up, I believe that the department would be willing to review.
Can you talk a little louder?
The department would be willing to review the decommissioning plan and the instrument as it came in. If we had concerns, we would check the box, and I assume that it would come before the commission, and the commission could open a comment period at that time and get other entities involved. The decommissioning plan right now states that it's about a $30 million project with $40 million project with $4 million decommissioning fund as of now. So we would expect that when that filing came in from the applicant, that they would talk more about just decommissioning. They would perhaps talk about some of these other things that you're talking about, Commissioner Tuma, a pipe sitting next to an open trench with a bunch of union workers waiting to get paid. What those potential costs could be in that filing, and I believe that that the burden would be on them, and we would make sure that they met it, and we could move forward with that.
And sorry, I'm not trying to be frustrating here, but so we have Commissioner Tuma's 12, right? And then we have staff 12, and then we have Brusvin 12, right? Is that what? Well, I want to hear I don't know what we're,
Yeah.
I'm just trying to
you're
pull
accurate.
together some sort of, Commissioner Tuma, what are you giving the conversation? What are you thinking of? Your 12 is still the best thing?
I don't know, Madam Chair, that's for deliberation, but there is two options, which is,
Can you help explain what you see as the key difference between yours and then Ms. Brusvin's 12?
key difference between the staff's and mine combined is that there would be a separate docket open, and there would be notice and comments about what would be the appropriate decommissioning plan and appropriate worker protection, landowner protection plan, and I would assume that they would file that in advance, and we would open a docket and there would be discussion. The slightly modified summit plan, or Ms. Brusman's concept, would be that that would be done in the normal course of the permitting process, where when we go to scope and the profile process that's done normally, they would present a decommissioning plan and a worker landowner protection instruments or plans. And then if there's a problem, the department would step forward and say, we have a problem with this, and then comments and things would be brought at that stage in our normal course, which we don't typically do. Usually it's all taken care of, but in the normal course of our permitting. So there wouldn't be a new docket opened up. And so that's it's a process question. I think the protections are there in both situations, but there's an upfront process with the way it's drafted now, where there's a wait and see process under the way that Ms. Brusman is recommending. I think that's an accurate assessment of the two different things that we're talking about, Ms. Brusman. You can correct me if I'm wrong.
Ms. Brusman?
Madam Chair and Commissioner Tuma, I think that's correct. If it's appropriate, I think we can meld those two. If you're looking at Summit's proposed 12 below, you would also be asking us then to file an amended decommissioning plan that moves the financial security to the start of construction and discusses those issues that you've raised today. I think you could do that with a pretty easy sentence addition.
We can
there.
take a break to do that, but
Yep.
conceptually, we can meld my suggested red lines on 12 into your Summit 9.3.0 or 4.
And then staff 12 seems to have a reference to the amount of general and environmental liability insurance that we need to pick up and put into the.
That is correct, Madam Chair.
that
That's a
as
very
well.
good point.
I just want to make sure that
Yep.
we're all like kind of, I think that the point, you've made really good points here, Commissioner Tuma, that should the project not move forward in its entirety, we need to ensure that there is a fund up front to help
Insurance, yeah.
ensure that everyone is.
That's a very good point.
Fully
And Ms. Brusman,
made
I'm
whole.
focusing on some sort of trust fund there. There is a different additional analysis of liability. That's still part of the permit, and you would still have to show that. And you're not saying that you're not going to show that. So we could include that language in there. It's going to be kind of duplicative, but it would be appropriate to have the language in there on insurance.
Ms. Brusman?
Madam Chair and Commissioner Tuma, yes, that's what's proposed in Summit's amendment to 934, is that we would discuss the general and environmental liability insurance coverage as part of that filing that was already a part of 9.3 or subpart 4.
So essentially, we'd be doing three things under our modified combined proposal. One is decommissioning, two is some sort of funding or protection of construction and landowners, and three would be liability insurance.
Madam
And all
Chair,
be dealt with at the scope time.
at the condition, yes, before the pre-construction
Reconstruction meeting,
filing,
yeah.
yes.
And Ms. Brusman, is there anything that's missing out of that proposal that the applicant has been required to fund or to prove in other states where you've obtained permits?
Madam Chair, not to my knowledge.
Okay, and to the department, there was just a lot going on there, but do you think that if we come up with some conglomeration of these three decision options that Commissioner Tuma just helpfully led us through, that is what the department would support, I would think, and would be consistent with your overall way that this has happened in the past with other pipeline projects, too? Or any concerns you want to raise that we're not addressing with regard to this?
Chair Sieben, yes, to the extent we are accurately following along what has happened here, we believe that the plan that's been proposed is something the department would be able to support and see through as described.
Okay, and
Just one last thing along
Yep.
this lines before we just, G is about just doing it all in one. And you didn't mention whether it is, I combined it together with this concept because it is really a short pipeline. and I'd hate to be sequencing it out. So I suggested that this is, when you do your plan and profile and your compliance filing, that's the beginning and the end of the project, in my mind.
Madam Chair and Commissioner Tuma, I think we just had some questions on the language for full project, but as you've described it here as the full 28 miles, that is how we plan to do it. I mentioned before that the capture facility construction may start before the pipeline, but I think we would have all of the information to make all of the pre-construction filings at the same time. Just note that I don't want to get too hung up on separate segments of construction schedules, but there will be a schedule for the capture facility that will be longer than the pipeline construction season, and we want to be able to get that started right in the season that we can do that, even if there's a timing restriction or other reason that we have to start the pipeline later.
Well, and that's the way I was thinking about it. It's North Dakota construction begins. That's all we need to know, okay? And that once that construction begins, you can come do your G, but G is the full 28 miles, not I'm going to do first half from Fergus to the Joe Smith's property, and then from Joe Smith's property to the river.
Madam Chair, Commissioner Tuma, and the language that they usually use, the 28 miles would be one spread, right, or one crew.
So if there's some better language to G that you would like, you can let me know, but that's what that's my goal is I just want to get construction to begin, and then you can start in Minnesota.
Madam Chair and Commissioner Tuma, I think with this conversation, we understand what you're getting at, and that is workable for the company.
And we still have some disagreement over whether a concern you might have with my second sentence of 11, which is I want you to stop construction if something gets stopped in North Dakota.
Your second sentence or last sentence of 11A?
Yep.
Madam Chair, Commissioner Tuma, that's correct. Because of the concerns I raised before, that sort of ceasing might not be the least impactful action to take. It may actually be least impactful to finish the activity that's going on, restore, and not make further progress. And so I do want to make sure that we are mindful of that real reality, that we are as least impactful as we can be to the landowners.
Did you suggest new language to that, Ms. Brusvin, trying to track all the decision options here?
I don't think she did.
I did not.
And then, so Commissioner Tuma, how do you want her to suggest language to your amendment, or Ms. Brusvin, did you have a suggestion of how you'd like to clarify that, or you'd need time, or I don't know?
Madam Chair, I would need just a couple minutes, I think, to.
Okay, then we'll keep moving on if that's okay. Commissioner
Those are all the
Tuma.
questions I had around that kind of staging and construction and timing and assurance during construction. So thank you, Madam Chair.
Commissioner Sullivan was next, and then Commissioner Hall.
Thank you, Chair Sieben. I have a couple questions. My first question to Ms. Brusvin and the company is, on your December 11th revised decision options, the company made changes to decision option 11 or 3L. Specifically, the department the department's language for the original 3L was that the applicant shall file with the commission any life cycle greenhouse gas emissions and life cycle report. And then the company changed that to the permittee shall file with the commission the captured CO2 volume. And as I read that I like the department's language because it's a wider net and it's, I think, actually a more valuable metric. The volume lacks context. I mean, volume, I'm sure that's what that the IRS is requesting as a part of the 45Q requirement. But if there is more information, and that if that's what has to be filed, I get it, you file it back. But like, if there are other reports that the IRS is requesting, that's the way I take the department's request, is to file those with us, because I think that's important contextual information. So I'm curious why the company changed that.
Thank you, Madam Chair.
Ms. Brusvin.
Commissioner Sullivan, thank you for that question. So there are a couple of different kinds of credits under 45Q, including for utilization of CO2. The IRS requires the life cycle analysis for the utilization credits. So that'd be like ESAF, use of concrete for other products, concrete, et cetera. They require that life cycle analysis in order to claim the credit. They do not require a life cycle analysis in order to claim the sequestration credit because that's based on CO2 captured. And so we wanted to correct this language to make sure that we were referring to an obligation the company has in terms of a filing that we made with the IRS. As currently drafted, we wouldn't have a life cycle analysis under that provision because it's, again,
So that provision of 45Q, there is no life cycle that's required. So you're just saying, okay, this is what's required. The volume is required under this provision.
Madam Chair, Commissioner Sullivan, that's correct. And then we would file that portion of the form with the commission, so you would have that information, same information that's going to the IRS.
Since it was the department's decision option and it resonates with the way I look at the world, can you just weigh in on that? I need to go through the chair.
Yes, go ahead. Department, please.
Chair Sieben, Commissioner Sullivan. Certainly, the department's intent in our initial language was certainly, we had the thought of if this information is available anyways, that would be great if it could get filed. But those of us representing the Department of Commerce are not tax attorneys, and it turns out we misunderstood what was required under this. When Ms. Rujan contacted me to share that, this was not required under 45Q, I followed up and understood both where our initial misunderstanding came from and then also why that my understanding is that she is making, accurate representations about that would not be required under this. And so given that those reports would not be required and would not be generated anyways, we agreed with the proposed modification that the information that would be reported to the IRS get filed.
So then, is there any, so just filing what is captured is sufficient then for what the purposes are that the department was looking for with this decision option?
The department's sort of thought process with recommendation was this information is being generated anyways, why not file it with the PUC? But given that we were unfortunately making an incorrect assumption that that information would be generated, sort of our basis for that recommendation wasn't accurate.
Is there, Ms. Brisbane, is there carbon that will be captured that would not be, you would not go to the IRS for 45Q?
Madam Chair,
Ms.
Commissioner
Brusvin.
Sullivan, no.
Okay, so then the number that the IRS has is fully inclusive of the captured carbon. So your language, then it seems like, okay, now, okay. Next question on decision option 11. My question with decision option 11 is the company has requested that it's 11C. The original language would the company change to require arbitration. So my question, yeah.
Madam,
Wait, Commissioner Sullivan, you're discussing 11C in the briefing papers or a different version?
I think it's what the company filed on yesterday, and it requires arbitration.
In a dispute with a landowner?
Right.
Ms. Brusvin.
Madam Chair, Commissioner Sullivan, it requires mediation if there is a dispute. Because the commission isn't typically in the business of dealing with compensation, we thought it was helpful to have a mechanism here because, again, I don't think the commission we want to resolve those issues if they are. So we just suggested language that you have used in other contexts, that we mediate any dispute if there were one. Again, we
So if there, okay, that's, okay. So if there is a dispute that arises out of the mediation that the mediation doesn't solve, is the company want that to just be resolved there at that point? Or, I mean, I would think that it should come back to the commission, or that it could come back to the commission if the person.
Madam Chair, Commissioner Sullivan, I think the landowner would have a couple of options. They'd have options under their easement. This will be a condition of the permit, so they could file a complaint suggesting we're not in compliance with it. I don't know if the commission wants to be in the business of resolving these disputes, so I would let you decide that. But we wanted to offer the mediation step so that it wasn't, there was at least a step here if we got to a situation where there was a dispute about the actual crop damage.
Okay. I'll talk to staff a little bit more, and then I might come back to that. And then the last question I had is regarding, and this is more, I'm just curious about this, if the company has this information. I didn't see it in the record, but it may be in there. But my understanding is that 45Q, the tax credit, is if you are using 45Q and you are only sequestering it, you get a higher tax credit. If you're using enhanced oil recovery, you can still get you can still apply for the tax credit under 45Q, but you get a lower amount.
Ms. Bruceman?
Madam Chair and Commissioner Sullivan, you're correct.
So that tells me that there's got to be some kind of break-even point where the company would say, maybe it's the price of oil, at this point we would forego the amount, the higher value under 45Q because the revenues coming in from the higher price point of oil would be worth it. And I'm wondering if you have that information anywhere, or if maybe that's not the break-even point, or there's another way to look at it. But does the company have that information? And could it share, based on what I've heard in the recommendation, or based on what the company has stated in the filings in public, that you're not planning on doing enhanced oil recovery, but you also have left the door open a little bit. So I'm just curious, what's your decision, or what's your thinking on that? Under what condition would you do it?
Ms. Bruceman?
Madam Chair, Commissioner Sullivan, the CO2 that is sequestered is captured and then transported on this project will be permanently sequestered. That is our contract with the Green Plains ethanol plant. That is how they lower their carbon intensity score to best meet their objectives. And so as to CO2 on this line, I don't think the door is open.
Okay, so it's the contract that you have forecloses your whatever plans you could think about if the price of oil were higher.
Ms. Bruceman?
Madam Chair and Commissioner Sullivan, that's correct.
Okay.
In addition, I would just say that the reason the quote door is open is the company is a common carrier. It cannot discriminate against shippers, and so on a larger system, we could not say definitively no. And that's why you see the statements that say it could be a possibility, those kinds of things, because the company is a common carrier. But in Minnesota, on this line, the contract is for permanent sequestration.
Okay, thank you.
Commissioner Hahn?
Thank you, Chair Siebert, for the company. So what is the current status of the land use agreement? I heard from staff it was 80-some% at the time of the hearing. What is the current status?
Ms. Bruceman?
Madam Chair and Commissioner Hom, it remains at that 89%. We continue to have very productive conversations with all of the landowners, but we have not acquired any additional easements since the hearing date.
So what is the number of the landowner in that 11% remaining?
Ms. Bruceman?
Madam Chair and Commissioner Hom, 7.
7, okay, thank you. And what is your current status of the South Dakota permits?
Ms. Bruceman?
Madam Chair, Commissioner Hom, the company has reapplied for the permits in South Dakota just in the last couple of weeks. So those are in their process. They have about a 12-month process, and that's begun.
Okay, so if we go with the Commissioner Tuma's option in 11A, I don't have to ask for additional condition, but if we go with your modified 11A, probably we need to put the condition on South Dakota permit too, because in my view, without South Dakota pipeline, I don't see any business case for this pipeline.
Ms. Bruceman?
Madam Chair, Commissioner Hom, that's certainly something you could consider. I think we were focused on North Dakota because the project moves from Minnesota into North Dakota. And we, again, want the option when all of the appropriate permits are in place to begin construction in those two states to begin.
Okay. And then, probably is the last. If South Dakota impose certain condition, which is different from Minnesota, but we may need to consider as an additional condition to Minnesota, does company have any issue with revisiting and adding those conditions to your permit condition?
Ms. Brusvin.
Madam Chair and Commissioner Hom, I think we've been careful not to obligate one state with the actions of another state. I don't know that there's always alignment around those conditions. Certainly, we would want a final permit here from the state of Minnesota so we knew our expectations and could put forward the process to complete those. I don't think we will know from South Dakota for about another year, which would create some uncertainty for the project. So our preference would be not to condition Minnesota permit with unknown conditions from other states.
No, ma'am. But what I meant is later we decide to bring back this permit to impose additional condition based on South Dakota permit. Does company have any issue with it? I'm not just telling you that we are going to put that as a condition as of today. My condition is only initiation of construction of Minnesota project after South Dakota permit is issued. That's different from what you are just stating. No, I'm not going to conditioning South Dakota permit as our condition permit. But initiation of construction of the Minnesota portion conditioning on the South Dakota permit. It's similar to what we already have in 11A. Additional discussion was if South Dakota permit has additional condition, if Minnesota Commission is reconsidering your permit to include additional condition received from South Dakota, does company have any the issue?
Madam Chair and Commissioner Hom, I think we would. We have a full record here around a 4-inch pipeline in the environmental setting in Otter Tail and Wilkin County. There's a much more extensive footprint in South Dakota with different resources crossed and a different record that'll be created. So I do think we would have concern with kind of reopening this permit on the basis of conditions that were developed under a different set of facts in a different state.
Okay. So why people in Minnesota has to have a less condition than the other states? If you guys can give other state certain condition.
Madam Chair and Commissioner Hom, I don't know that I would agree with that premise that we've given other states things that we haven't in Minnesota. Each of our regulators operates very different processes, and we've had different parties with different concerns in those different proceedings. I would say in many of our other states, they would say Minnesota is more extensive, right? You have the full EIS, you have a very extensive route permit with a lot of pre-construction conditions that I think thoughtfully mitigate the impacts that are in this record. So I don't know that I would agree with you that we've agreed to more in other states. We have certainly reached agreement with parties and addressed specific facts that have come up in those proceedings.
I'm not saying that you are agreeing with other state with a different thing here. In case you had to agree with the South Dakota Commission to grant additional condition, which we didn't think about.
Ms. Brusvin.
Yeah, Madam Chair and Commissioner Hom, I think my concerns would still be the same, that we wouldn't have a record here in Minnesota for adopting those. It's possible the company will be before you with additional filings, and certainly you're always, able to consider the full record that's in front of you. But I think without a record here in this state, again, it's important to us that we have a final permit and known conditions that we could move forward with.
Okay, thank you.
Well, it would be fair to say, though, Ms. Brusman, that, Madam Chair,
Commissioner Tuma.
you know, and you accept the fact that we have opportunity to reconsider at any time. You would probably just object at that time, the reconsideration. So I think that's where you're kind of talking past each other. You recognize that we can reconsider this pretty much at any time for pretty much any reason. I mean, we have to develop it on the record, but we could.
Ms. Brusvin.
Madam Chair and Commissioner Tuma, I think you always have authority as a regulator to look at and assess your docket's reconsideration. Obviously, has a particular window and set of facts, but certainly you would have to have a reasoned basis for any decision you'd make in the future.
Ms. Brusvin, if along the lines of Commissioner Hom's question about you have not reached agreement with approximately 7 landowners for the duration of this project, and as you know, and the audience knows, Minnesota does not grant eminent domain to a company like Summit. So if you don't reach agreement with any of those 7 landowners, but we grant a permit today, how do you see that playing out? Where if the easement isn't agreed to, then what will happen?
Madam Chair, thank you for the question. So again, we have very productive conversations, I think, with all of these landowners. We're hopeful we'll have 100%. If we don't, you have a permit amendment process where we would come back to you and ask for a change in the route that would be reflective of the agreements that we have. And you have conditions already laid out in this decision options that are before you. Obviously, we have to have agreements in place before we can start construction.
My next question is about the tribal engagement with Summit for this pipeline route. Not everyone in the audience probably knows, but the commission had a public hearing with tribes, and all tribal nations in Minnesota were invited and commented, not in particular on Summit's project, but just on CO2 pipelines in general. And I don't think Summit was even a part of that public hearing, but I did appreciate then seeing that in the EIS, and the judge mentioned this, that the tribes have been afforded the opportunity to accompany archaeological crews along the entirety of the RA South route. And Ms. Brusvin, because this doesn't always happen in all pipeline cases, will you please outline the steps that Summit has done to ensure that tribes had input into your preferred route here as it relates to cultural and archaeological surveying?
Thank you, Madam Chair. So Summit has a strong commitment to its tribal engagement, and it started very, very early with very broad outreach across the entire Summit Midwest Carbon Express footprint, including the tribes in Minnesota and North and South Dakota. And through those engagement opportunities, there were changes made to the route, not in Minnesota because there weren't actually concerns raised along this 28-mile segment, but there were in very close proximity across the border, and Summit made changes early on to avoid those impacts. In addition, we did reach out broadly to tribal cultural resource specialists and asked for their engagement in the pre-construction surveys. And as noted, we had very good participation from a number of tribes in the state, and have completed survey on over 98% of the route for RA South. There were no additional cultural resources identified. We also have a plan in place to make sure that if during construction resources were identified, that they would be avoided.
I just want to publicly thank the company for doing that work. It's not always well understood by parties, but it certainly is something that the commission values and was really important, at least just speaking for myself, to see that that did happen in this particular project. So that part of it, I think, is really great. Are there other questions? Commissioners, do you want to take a break? And we could take a break, or we could proceed with other questions. Break.
No, ma'am, I was just agreeing with you. I only had interest around decision option 12, and we need to speak with council.
Okay. Let's take a break then. I think we might need, I'm just guessing, 20 minutes. Do you think that's enough? And if commissioners have other questions when we come back, we can do that before moving into deliberations. So the commission will stand in recess until 11:45 a.m. The commission will come back from its recess, and Commissioner Tuma, I think you and Ms. Brusman first had discussed some language to modify 12, was it? And so did you have did you want to talk us through that or put up new language that?
Language we've talked about there. Sorry. I appreciated what you're trying to do with your 12, Ms. Brusman, but I'd rather have a motion to amend the permit as opposed to actually trying to do the actual language. So I'm trying to accomplish that so that we're amending the permit to require the permittee prior to construction to create and fund sufficient financial instruments to protect against failure of complete construction and fund decommissioning, and then number 2, slightly changed, and then take out the language with regards to executive secretary starting another docket. So this would be a permit amendment. As we normally do, our staff would look at it and draft up language, but I didn't want to start redrafting today.
And so, Commissioner Tuma, just walk me through this again. This language is amend the permit to, so the applicant would have to file in this docket dollar amount, I suppose, for the funding or to determine what amount is a sufficient financial security instrument for environmental and general liability? Is that?
So they would have to do 3 things. 1, a fund for decommissioning, whatever their decommissioning plan is going to be, which we have some of that on the record already. They would have to file another fund for protection against failure to complete construction. And then they would also have to file a general liability, what their general liability insurance is going to be.
Sorry, Commissioner Tuma, we're just going to take a quick recess.
I see that. And I see because I have the same problem.
I did too a couple weeks ago. Just asked. Yeah, there we go. We'll come back from our recess, and Commissioner Tuma, we're talking about the language that was on the screen. If, Ms. Fazio, you could put it back up, please. And we're just talking about the top language, right, Commissioner Tuma?
That is correct, where it says Tuma 12.
So, Commissioner Tuma, you were saying that this is, the idea here is to ensure that prior to construction, there's money available a financial security instrument, like was done in other states, I understand, to protect against what would happen if the project didn't move forward, but they'd already started construction. And then a separate thing for decommissioning, and then
Also liability insurance.
and liability insurance. And so first we'll go to the department, and what do you think of this amended motion or decision option here? Ms. Arnold.
Chair Sieben, we just have a little bit of a confusion. Would this be adding a condition to the permit instead of amending? Because
Mr. Levi, then please state your name for the record. Welcome.
Andrew Levi from Minnesota Department of
Oh,
Commerce.
you already did. Sorry.
Yeah, I'll talk louder. I guess I just have a question. Is this the filing, Madam Chair, Commissioner Tuma, is this the filing that you intended that we would review?
Yes.
So I guess my only question is the phrase prior to construction. While of course we want the money there prior to construction, I would rather have that say perhaps with the plan and profile, prior to the plan and profile, something along those lines that gives us the opportunity to review that, as opposed to here it's the day before.
That was my intent. It was kind of that they really can't commence construction until they do the plan and profile and give you all that. So at that time, when you meet, the pre-construction meeting was what I intended. So if there's some more precise language that you want, that was my intent.
Okay. Okay. Yeah, I think prior, there's the language in there that will, 30 days prior to the plan and profile or whatever that kind of plan and profile is language. I think staff can
That's why I
address
didn't
that.
want to actually amend the permit, use the permit. I wanted to just kind of create a statement, and then staff will draft language that you will see and Ms. Brusman will see prior to the final permit.
And then Commissioner Tuma, this, just because there's a lot going on here, then this is new 12 that would replace all of the 12 in the decision options.
That is correct, Madam Chair.
Okay, and so we understand that. Ms. Brusman, what are your thoughts on the Tuma 12 now, the new version of it?
Madam Chair and Commissioners, I think with the clarification that Mr. Levi just had in terms of the timing and the fact that this would be a permit condition in the permit as it's issued, I think it accomplishes the discussion that we had earlier.
And Ms. Brusman, you agree with the way I'm thinking about this, that prior to construction, the company will file a financial security instrument that would protect against, like, hopefully what won't happen, but that the project will be stopped prior to it being completed. So essentially we're leaning in heavy on ensuring that if the project moves forward, there's a fund available. I mean, the project moves forward, you start construction, and then something happens, there will be money available to compensate landowners. That's your understanding and what you think part of this language does.
Madam Chair, I believe so, yes. It would, in that scenario, ensure that there were sufficient funds to complete whatever work needed to be done to minimize impacts, right, and fulfill the obligations of the company that are still open or wouldn't be complete because the project didn't go into service. So I think so, yes.
Ms. Brusman, because it doesn't say a specific dollar amount here for these funds, that will be filed in this docket, and the department will review it prior to you getting your permit to construct. Is that your understanding?
Madam Chair, yes. Prior to the authorization to construct, we would file and they will review.
Okay. Sounds good. And then commissioners, one other question I had that in reviewing with staff here, so the company proposed modifying the CO2 detectors, and the department, I didn't track do you still support adopting 3J, or do you support the new, the summit language that says they'll discuss with landowners the possibility of having CO2 detectors? Ms.
Chair-
Arnold.
Chair Sieben, the department supports the original proposal, which would first start with a good faith discussion, including the possible positives and negatives to those detectors, but then if a landowner at that point does request either an outdoor detector, that it would be provided at someone's expense.
And so that's 3J as finding 622, correct?
Correct.
Okay. And then, staff, could you put up the language that we discussed in the briefing about, in my discussion with staff just now, about additional notification to the landowners who have not agreed to the permit? And Ms. Brusman, this is a question directed first to you. For 11, if we grant the agreement, or I'm sorry, if we grant the permit today, there's additional notification in here that the company, you'll tell landowners with whom you've not yet secured an easement that the issuance of the permit by the commission doesn't change the fact that the company doesn't have eminent domain authority or grant the company greater rights associated with land acquisition.
Madam Chair, yes, we can do that. I think we would do it as part of the mailing that goes out to all landowners within 30 days of issuance of the permit. I think we could do that.
Okay, sounds good. The department doesn't have any concerns, I would assume, with that. Okay, thank you. And then Commissioner Tuma, did you want to make an overall motion, and then, or we can step through it more slowly, or
Sure.
Do commissioners have other questions before that? Okay. So because there are just a lot of different
Moving parts.
decision options.
So here's what I have in my notes, and hopefully I get everything covered. I would move decision option 1, decision option 3, with only Summit's modification to 3L, and keep the DOC's recommended 3J.
Wait, sorry, I didn't follow that.
So we're on decision option 3.
And you would move 3J and L only?
No, all of them,
Oh.
except 3J stays the same as DOC is recommended, but L would be modified to adopt the changes on the permitting requirement that they have to give life cycle information. So it'd be Summit's recommended 3L. Then I would move, let's see, I got to get the other ones in between. 6 and
Commissioner
8.
Tuma, can I just,
Sure.
so we have 1, and then if you just say 3,
3.
and then you have
A through K
A
as
through
written
K,
in the staff, and then 3L would be Summit's new 3L.
Summit 3L. Okay.
Exactly. And then turning the page, it would be 6 and 8. Then I would move 11. I would move my 11A. I wasn't convinced by modifying that. There's enough protections in there. If construction stops, you can always come to us in the last sentence and ask for it to be restarted. So it'd be Tuma revised 11A, then 11B as is, 11C.
Just a second. Commissioner Tuma, Commissioner Hom has a question.
I thought that we have a revision to 11B.
Ms. Fazio is going to put up the new 11.
The
Tuma,
chair, yeah, chair's revision to the 11B. So you are moving that or the original B? Okay, thank you.
You're right, I did jump to C right away. I didn't, thank you, Commissioner Hall.
Thank you for reminding me about what I was doing too.
So I have my Tuma revised 11A, Sebin revised 11B, Summit revised 11C, D as is, Summit revised 11E, and Summit revised 11F, Tuma 11G.
What is that one again, Commissioner Tuma? I just can't remember.
That is, the permittee shall, at the time of submitting their plan and profile, just do a one whole project. There's not, they don't get to segment it, which they,
Construction can't begin until all components are done?
all components are submitted at one time. In other permits, we allow them to break it up into segments, and they agreed to that one. And then HOM 11H, the new revised 12.
Wait,
On the screen.
12 is not on the screen yet. Hold on.
It was on the screen, but, and then 13 and 14.
12 or 5.
I think I got the landscape. I'm going to look at Craig to make sure I'm got it covered. Okay.
Ms. Fazio, can you put up the TUMA language we talked about? Or what was your TUMA one? All
12.
components of the plan and profile?
Oh, that's G. That's in your, you should have got it pre-filed. That's,
And did we ever ask the department you're okay with that? Or don't have concerns with it?
Chair Stephen, sorry, just to verify, which number specifically were you asking us about our concerns about?
12G.
So the G up
Or
there.
11G.
Tuma G.
Chair Stephen, Commissioner Tuma, the department does not take a position on 11G.
You're giving a heads up, but I think, do we have other questions on the motion? Commissioners, do you want to discuss the overall motion before we vote? No? Okay. Staff is good with the motions clear? Okay, all in favor of Commissioner Tuma's motion, please say aye.
Aye.
Aye. Opposed? The motion prevails 5-0. Thank you very much, everyone. The commission will stand in recess now until 12:45, and then we'll take up Xcel's rate case at 12:45. Thank you, everyone.
suppose that's a good thing, right?
The commission will come back from its recess and take up our final docket, which is the Xcel rate case. Mr. Manning, when you're ready, please introduce item number 4.
Thank you, Chair Sieben and Commissioners. Today's final agenda item is docket number E002/GR24-320 in the matter of the application of Xcel Energy for authority to increase rates for electric service in the state of Minnesota. The questions before the Commission today are, does Xcel Energy's application comply with the filing requirements of Minnesota Statute 216B.16, Minnesota Rules Parts 7825.3100 to 7825.4400, other relevant Minnesota statutes and Commission rules, and relevant Commission orders, and should this matter be sent to the Office of Administrative Hearings for a contested case hearing, and if so, what should be the scope of this hearing? There have been 2 new filings since staff's briefing papers have been filed. Commissioners Hom and Tuma have each filed proposed decision options. There is a minor correction to one of the decision options. On decision option 16, option A1 should read $24.663 million instead of $24.656 million. Parties have been advised that they will have 3 minutes for opening statements, and parties and staff are available for questions. Thank you.
Thank you, Mr. Manning. If the parties wanted to come forward. Do we know, Mr. Manning, is Electrify America online? Or are they participating in open
I believe
comments?
Mr. Willingham of Electrify America is online. I do not know if he has an opening statement prepared.
Okay, well, we'll first start with appearances then, please. Mr. Dobson.
Thank you, Madam Chair. Commissioner Ian Dobson with Xcel Energy.
And Ms. Campbell, or we'll just move down the road line.
Nancy Campbell for the department, and with me is Catherine Arnold to assist with legal issues. Virtually, I have Mark Johnson to assist with financial issues, and Anthony Fryer to assist with SIP eco issues.
And the OAG?
Good afternoon, Madam Chair and Commissioners. Peter Schultz with the Office of the Attorney General, Residential Utilities Division.
Cub.
Good afternoon, Brian Edstrom here with the Citizens Utility Board of Minnesota, and Brandon Crawford of CUB is also here. Thank you.
And Electrify America.
Hi, I am Anthony Willingham, the State Government Affairs Manager at Electrify America.
And Mr. Willingham, do you have an opening statement, or are you just available for questions?
I can provide an opening statement. I was going to reiterate what we provided in our written statement.
Okay. Well, we'll start this morning then with Xcel. Mr. Dobson.
Thank you, Madam Chair, Commissioners. I think I'll focus the time I have on the interim rates issue. So I'll start by saying that we recognize and we share the desire to moderate any impact for our customers that the cost increases that we're experiencing as their utility. And so I think it's important at the start of this to note that right now our current projections for 2025 show that the decrease in the amounts that we're going to be charging through our fuel clause next year are likely to fully offset, if not potentially more than offset, the entire original interim rate request that we have here. Meaning that even if this interim rate, even with our original interim rate request, the costs that our customers are going to experience next year are likely to be closely to flat. And we think that's a testament really to the strategies that this commission has encouraged, which we've known for some time is going to have a shift from our fuel to our base rates. So with respect to the specific arguments that we're seeing on interim rates, I'd first say that we disagree with the OAG's claim that our past rate cases constitute an exigent circumstance here, and we disagree with the data they used throughout their comments. And that's because despite that narrative, the fact is that our customers' bills and the overall revenue that we have collected from our customers has grown substantially slower than it has for the other Minnesota Electric IOUs since 2010. And the average percentage that we have received of our original rate requests is right between the other electric IOUs. So the idea that our revenues and our customers' bills are going up much faster than others isn't correct. It's actually the opposite. Second, we think that the wildfire mitigation expenses that we've discussed in our case are really critical to our efforts to continue providing safe and reliable service for our customers and communities. And we understand, obviously, that the Commission is going to need to review those in this rate case for reasonableness and a potential refund based on your decision. But the argument to exclude these costs before that review, I think, confuses what is the same nature and kind of an expense with the reason for the increases in these expenses. And so to put that differently, the fact that these types of expenses, whether they be vegetation management, pole replacements, or what have you, are going up because we are dealing with a new threat doesn't mean that those expenses are a new, different kind of expense. So we think we properly included them in interim rates, but we've, in the nature of compromise, we proposed this middle ground that we think sort of gives us the confidence to be able to move forward with these safety endeavors, obviously knowing that they are subject to review and potential refund, but while substantially lowering the interim rates that our customers would experience in 2025. There is also the insurance issue, but I realize I don't have a lot of time, and so for the sake of that, I am happy to go through decision options if you would like, or we can save those for a different time.
Well, let's just save those for a different time. I recognize we didn't give a ton of time for opening comments, but that seemed like a good decision at the time. We'll next hear from CUB, please. Mr. Edstrom.
Thank you, Chair Sieben. We're concerned about several aspects of this rate case filing, which comes quickly on the heels of Xcel's last electric rate case. The proposal would raise residential rates by 14.5%, including through a $5 increase to the basic service charge. It also includes another significant increase to ROE, despite the Commission's recent finding that a 9.25% ROE was sufficient. And in light of this, in our view, it's important that customers be protected from not overpaying in interim rates. So on the wildfire risk issue, we understand the company's concern on that, but we do think it's appropriate to exclude those costs from interim rates. We noted in our written comments that several of Xcel's witnesses in direct testimony described those costs as newly incurred in this rate case and not incurred previously. And for that reason, we do feel additional record development is appropriate and needed before the Commission approves partial recovery of those costs. And Xcel had argued that some of those costs might be eligible for deferred accounting. We think that argument is a bit contradictory, contradicts the position on their inclusion of some of those costs in interim rates. So to include them in interim rates, Xcel argues that they reflect some costs that are of the same nature and kind as previously incurred costs. And then when seeking deferred accounting treatment, they argue that they are unforeseen and unusual costs. And those are, I think, contradictory arguments. So in the interest of protecting ratepayers while additional record development is provided on those issues, we continue to recommend that those costs be excluded from interim rates. And I'll leave it there, and I'm happy to read our preferred decision options if you like.
Okay, we'll do that later too. And Mr. Willingham from Electrify America, did you want to provide a couple minutes of opening comments? Or just...
Sure, thank you for the opportunity. I will be brief. I'm Anthony Willingham, the State Government Affairs Manager at Electrify America. I appreciate the opportunity to give comment. Obviously, as a customer of the utility, we would like our rates to be as low as possible. So I appreciate, again, the opportunity. I'm here just to ask that the Commission exercise caution when fielding a request for a rate increase. The profit margin on direct current fast charger stations are already extremely slim. Per session, they are pennies. So raising rates even slightly can force a station, an existing station or future one in development, to no longer pencil out. And at a time when this industry is facing a lot of uncertainty, we are really looking for predictable and favorable regulatory environments to safely park our money and find investments. And higher rates can jeopardize that. So for those reasons, we just ask that the Commission exercise caution when fielding a rate increase. Thank you.
Thank you, Mr. Willingham. Next, Mr. Schultz, please.
Thank you, Madam Chair. Xcel's proposed rate hikes for 2025 and 2026 continue a long trend of the company seeking huge rate increases at almost every available opportunity. Combined, the proposed increases total nearly $500 million and would add $166 to the bills of a typical residential customer per year. About a fifth of that is earmarked solely for growing the company's profits by increasing its allowed return on equity. Xcel filed the proposal just one day after its parent company reported year-to-date profits of $1.5 billion. In a recent investor report, the parent company touts a successful strategy that has allowed it to, quote, consistently achieve our financial objectives, delivering dividend growth for 21 consecutive years. Xcel's successful investment strategy has had some unfortunate consequences for the Commission and for ratepayers. Since 2011, Xcel has asked for a rate increase in every year but one. The company is unique among Minnesota utilities in the size and frequency of its rate increase requests, which often take the form of multi-year rate plans. The Commission has typically approved far less than what Xcel seeks to recover, but Xcel's base revenues have still grown by close to $1 billion since it began its practice of filing yearly rate increase requests. As a result, Xcel's customers have seen their rates climb well above both other Minnesota utilities and the national average, while Xcel disconnects record numbers of customers struggling to pay their bills. Taken together, these circumstances support the Commission finding exigent circumstances and reducing Xcel's interim rates request in this case. Decision option 14 would hold the interim rate increase to 51% of Xcel's proposed final increase for 2025, consistent with the company's history of seeking about twice the amount of revenue that it ultimately is able to justify. If the Commission doesn't find exigent circumstances, however, Xcel's interim request still needs to be reduced to comply with the statutory formula. Xcel's request includes at least three types of costs that are not the same in nature and kind as those reflected in its current rates. First, as you've already heard, Xcel's request includes wildfire mitigation costs. Xcel has had to contend with major wildfires in both its Colorado and Texas jurisdictions, but it has never before included specific wildfire mitigation costs in Minnesota rates. As my colleague at CUB noted, by proposing deferred accounting treatment for those costs, which we would oppose, Xcel has conceded that those costs are unusual and unforeseen, which is not an appropriate cost to be included in interim rates. So the Commission should adopt decision option 16A2 to remove those costs from the interim test year. Second, Xcel's interim request fails to follow the insurance premium methodology that the Commission required in the last case. Decision option 16B would ensure that interim rates reflect the same smoothing method that the Commission used in Xcel's, and that is reflected in Xcel's current rates. And finally, Xcel's request includes a grid reinforcement program that the Commission rejected in its last case. Decision option 16C would remove those capital costs from interim rates. I think I'm nearly out of time, so I'll just note in closing that the OAG supports denying the 2026 proposed interim rate increase, or at minimum deferring that decision on that. And I'm happy to go through our full decision options at any time the Commission prefers.
Thank you. Ms. Campbell.
The department supports decision options 1 and 7, and for this decision option, we appreciate that Xcel supported the additional 5 months for this case, and note we have several ongoing contested cases that need to be handled before getting to the Xcel multi-year rate plan, which will be a heavy lift and require significant resources to ensure we do a good job. We support decision options 9, 10A through 10A to through N. But we note that it might be helpful to get a little bit of direction on 10N, because so we can better understand that concern. We support TUMA's 10-0 and HAM's 10-0, although we would note it might be difficult to determine the cost impact for other states' wildfire risks on insurance and capital costs in this rate case. However, we will make every effort to do so. For example, for ROE, we may be able to consider wildfire risks in the proxy group selection. For 11, 11A, 12, and 13 that we support, we appreciate this support, especially for 11 and 11A. The department will likely look for consultants for wildfire, grid mod, advanced technology, and demand response, peak demand, and we will likely get a separate consultant for prepaid pension assets. For interim rates, we support 16, A2, and C. Interim rates, as you know, are supposed to be the same nature and kind as allowed by the Commission's order in the last rate case, which means that new costs and costs that have been denied should be excluded from interim rates. The department believes the wildfire costs are new costs in light of a new Xcel witness that covers wildfire costs for the first time, and believes that these wildfire costs should be excluded. Additionally, as noted by OAG, the capital costs for the grid and reinforcement were denied in the last rate case and therefore should be excluded. We do note that it's hard to tell if the adjustment that Xcel made for hosting and grid is really grid reinforcement costs, since there's no mention of reinforcement. So that's why we have that concern. We do not support decision option 17 for the deferred accounting. We don't think this request meets the requirement for deferred accounting of unusual, significant, related. It is related to utility operations, but it definitely is not unusual or significant. And we think it sets a bad precedent for interim rate recovery to get around it. We also support decision option 19 to defer the decision on the 2026 interim rate increase, with direct testimony tentatively scheduled for around the August 2025. Parties will have better information as to whether a second year interim rate increase is needed by the time, by October 1, 2025, when Xcel would be refiling its request 90 days prior. We also support 21, 22, and 24. We support 26 or 27 for the demand response peak demand and not 25. Upon further review and consideration, the department believes a holistic look at demand response and peak time demand programs in either the rate case or the Commission Investigation Advanced Rate Design Docket 24115 would be preferred, rather than addressing part in the ECO-SIP and part in one of these two proceedings. Decision option 26 in the rate case is our preferred decision option, since it would also let parties consider impacts of these programs on the rate case, and all interested parties are likely in this rate case proceeding. We could accommodate decision 27, but we would have some language changes if you do it through 27. And I think that's it. Finally, we support the administrative and compliance issues noted in 20 through 31.
Okay, thank you. Let's start, commissioners, at the beginning of the decision options with questions, just so we're kind of moving in a reasonable manner, recognizing it's hard to do that. But
Look at Xcel's preferred decision options up front, or is that? That might alleviate some questions.
Okay. Right. So, and other parties who, if your decision options are not as they're in the briefing papers, then let us know if you want to clarify your decision options or any changes. Mr. Dobson?
Sure, Madam Chair, I can walk through them. We would support 1. We are fine with 7. That is, of course, if the commission does not choose decision option 20, which is how it was reflected in the briefing papers.
Can you speak up a little?
Sorry.
Please.
I said we're comfortable with 7 so long as the commission does not choose 20 as well.
Mm-hmm.
We're fine with 9. 10, and I would include with that both of the Commissioner Tuma and Commissioner Hom decision options to that. 11, 12, 13. With respect to interim rates, obviously our original proposal would be 15 and 18, but the adjusted proposal that we've made would be 16A1, but that would need to be combined with 17, and then we would need 19 and 21.
In order to support
16A1.
16A1, you'd only do that if it's deferred accounting.
We support that with 17. Correct. One clarification on that. I think the staff noted that 16A2 was an Xcel alternative. We don't support that. And then we support 22, 24. For the peak time rebate, we are somewhat indifferent to this. Our preference would be either 25 or 26. And then we agree with the department on, we support 28 through 31.
Okay. And Mr. Edstrom, did you want to provide any clarification on the decision options?
Thank you, Chair Sieben. Yes, perhaps it might be helpful just for me to reiterate those that we support. I think there are some differences between briefing papers. We support 1, 7, 9, 10, including Commissioner Tuma's and Ham's 10-0, 11, 16, A, 2, and C, 19 or 20, 21, 26 or 27. We support the administrative options 28 through 31. And then finally, I don't think there's a decision option on this, but we respectfully request that the Commission grant our petition to intervene as well. Thanks.
Mr. Schultz, you kind of went through it in your comments, but anything else to add?
Thank you, Madam Chair. Yes, so I'll just clarify that we support decision option 10, including Commissioner Tuma, Commissioner Ham's decision options there. I think the other ones are pretty clear. We would oppose 16A1, 17, and 18. Those relate to the wildfire costs. But
Okay.
Beyond that.
That's good. And Ms. Campbell, I think you covered it, but anything to add?
No, I don't think I have anything else to add.
Okay, so commissioners, if we start from the decision options, I don't know if this is a good way to do it or not, but we'll just try it. So discussion on acceptance of of 1, 2, or 3, or questions, Then the timeline for suspension of final rates, it seems to me that everyone's kind of moving in the same direction around 7. But is there any discussion around that, around the timing? Referral to the OAH. This is starting in 9 and then 10. The standard rate case issues, Ms. Campbell, there's a footnote, and I know it was discussed in the briefing papers about, what the standard rate case issues, and obviously there's a lot to unpack there. I didn't hear a lot in your opening comments about just the fact that the department, this is not a good lead into a question. How would you first characterize, like, looking at the overall filing? What like kind of struck you in your experience of the magnitude or the kinds of increases that you think in development of the record will be especially notable or kind of take up a lot of the department's energy and time?
It's a little premature for us to do that with only having a few days to look at it. But certainly some of the issues that have been raised in this proceeding, we certainly will be looking at the insurance issues. We will be looking at the wildfire issues. We'll obviously be looking at rate of return issues. We know that there was a decommissioning filing filed, so we'll be looking at to see how that matches up with the rate case. We have a depreciation filing going on, so we'll be looking at how that matches up because we do see some changes that, I see a lot of those things. A lot of the things that were in that we had adjustments for in the last rate case, I see those coming back. And so those are a lot of the things that we're focused on, but until we dig into the testimony and read it, we don't know what all the issues are. So it's a little premature, but those are some of the initial ones that jump out at us.
And Mr. Dobson, the company certainly has the right to file a increase, and all of the costs will be looked at very closely by all of the parties here. But can you help characterize for the public and for the commission why the overall cost increase is, $500 million on top of, like, we're not even done with the current year increase right now? Like, it just seems like it's a lot. It's a big increase on top of a rate case that isn't even fully resolved, as you know. Like, there's still pending litigation out there related to the most previous rate case that the company filed with the commission. So help characterize, please, why the overall rate case filing is, or how would you characterize it in terms of the significant changes in cost since your last one?
Sure. Thank you, Madam Chair. I guess I would say I certainly understand the need for the commission to review this thoroughly, and we fully expect that. I think in terms of what is driving sort of the need for this rate increase, I think part of it is exactly what Ms. Campbell said, is there's sort of a lot of different pieces to it, but I think sort of big picture, we are putting quite a bit of capital in. We are building a lot, and we are putting a lot of that in service, and that's driving a big chunk of this. And I think that's related to what I said previously about how our fuel costs are going down. I'm not going to say that that's the entire reason our fuel cost is going down. It's not, but there is a correlation. I also think that one of the dynamics we've seen, and you see this continuing at least into the first year of our rate case, is sales declines that we have had. And while that is in part related to a lot of the DSM work that we have done, that creates a scenario where you do have increased rates. You have some rate pressure, but it's a net savings for customers. And you see some of that tail off into 26 as we're projecting some sales growth again. So there are a lot of pieces, but we do think that when you kind of step out of this, and we're certainly happy to talk about this more in the rate case if it helps, but when you pull back out to, like, what is our customers' experience, we think that we are on a trajectory that is generally that is continues to be affordable for our customers.
And just on a follow-up to that, some of the costs that are being incorporated into the rate base that's growing the overall rate base increase are projects that are either currently in the res but are not yet online or in service is like the general way it works. I think it's fair to characterize it like that. But what we're seeing in this, it looks like from looking through the rate case filing, but there are some that are online now that will be, that are going into base rates when final rates will be implemented in here. So for example, some wind repowers like Grand Meadows, Nobles, and Northern Wind Farm, I think, are examples that are in the res now, but will move into base rates.
Madam Chair, that's correct. There's some rolling from one to the other. That's correct.
And then as more renewable generation comes online for the utility things like, Churco Solar and other projects that are sort of in the res and in that pipeline, those projects are still, they're in the res currently and likely will remain until they're in service, and then they roll out of the res into base rates. That's correct?
That's correct, yes.
So like looking forward, some of that, the overall pressure here on the increasing rate base is still kind of prospective. It's still coming as it's related to those list of projects, correct?
Madam Chair, I think as we roll res or those types of projects, as we build them, when we roll those into base rates, that would sort of increase the base rate portion of our bill. But in those proceedings, should they come, that you're right, that wouldn't have an increased effect on our customers' overall rates.
Mm-hmm. And then how much, and Mr. Schultz referenced this, he said that 1/5 of your overall requested increase here is related to a higher cost of capital. Do you think that that's generally a fair characterization or sounds about right?
Yes, Madam Chair, that sounds about right.
Okay. And then the other drivers of the rate increase looks like, and these will be looked at more carefully by all the parties, to be clear, is administrative and general composes a $67.8 million increase. Can you characterize a little bit more what you think that is? What's like, are you hiring $67 million more worth of employees perhaps, or you're working on downing the number of people with arrears and that takes more? Or is it too hard to characterize what, it just seems like that's a big number, and I'm curious what that is.
I will confess, Madam Chair, that I can't remember all the breakouts of those categories, but I can say to your 2 points that it's not that it's not an entire labor increase expense. There may be some labor woven into that, and I can say that it is also not related to increasing arrears or anything like that. It's not those. I can't remember when I break that down what's in that lump. I can figure that out if you'd like to know.
Well, it was all in here. I'm just, in C, there's customer accounting, $16.5 million, customer service and information, $34 million increase, and then administrative and general for $67 million, and then depreciation, $112 million. And, I'm sure the parties will look at that, and I'm just raising it because I think that these are all significant increases that overall will impact customer rates if that full amount would ultimately be found to be just and reasonable. Commissioner Sullivan, you had a question earlier.
Thank you, Chair Sieben. I was just it was a follow-up, but a point maybe Mr. Dobson, I don't remember seeing in the record. was probably in there, but I'm not sure why I didn't catch it. But you'd said that sales have gone down or decreased, and if you could just unpack that a little bit.
Sure. I wish we would have put this in response to the OAG's comments, but we couldn't pull it together. But when we looked at, so there's two pieces of this that I'll explain. When we looked at sort of what has happened to our sales since 2010, we, based on EIA data that we had looked at, that we report, and our sales have been going down from 2010 to 2023 at a rate of around 0.75% per year. And so, and that's related pretty heavily to our DSM activities. And so, that's going down, which is obviously creating, which is meaning that we haven't needed to make a lot of investments that we otherwise would have, and it's saving customers. But what it creates is that dynamic where these fixed costs you have are being spread over fewer and fewer sales. What is in this rate case, what I will say is what we're anticipating is generally a continuation of that decline, I think, through the first part of the test year, and then you're starting to see an upward trend in 26 because of what we're anticipating, some data center load coming online. And so there's a small, that sales thing is turned around a little bit in 26. But from what we have experienced, it's been a declining sales, and it's been quite rapid.
Okay, thanks.
Commissioner Hahn.
Thank you, Chair Sieben. I'll have a follow-up to that question and a few more. Is it per customer sales going down, or is it total sales going down?
It is our total sales.
Okay, so that's why we need to be careful about when total sales going down. That there could be a different reason. And then, for example, residential customer per household sales is going down. It's not necessarily because of DSM, but building code and other things. So we don't need to argue here, but I think overall your sales fluctuate based on the different reason and different things. So I think we need to be careful when we are building the record of that issue. Being said, I need to explain to Ms. Campbell. Ms. Campbell wants to know a little bit about what about the 10N, right? You said you need some guideline. That is, Xcel has a policy, I think even before state was going with the carbon-free standard. The company had a catchphrase, fuel to steel, that is converting traditional generation to renewable by not consuming fuel. That means their fuel became rate-based, as Mr. Dobson mentioned. That means today's customer is potentially paying for the fuel cost of the tomorrow's customer. So that's why today's customer has to pay for tomorrow's customers' fuel in the form of capital. So I'm not blaming anybody. This is a new paradigm. That means we have to have a way to think about managing fairness between today's customer and tomorrow's customer. Why today's customer has to bear the burden of the fuel cost of the tomorrow's customer. To me, that's not fair. So that's why I think hopefully we can develop some record to potentially address that concern. So some people may argue that, oh yeah, we are already doing it because even on the fossil fuel, I think typically after depreciation of the several years, usually ratepayers are paying less. But two difference there is fuel costs never had a rate base, so it wasn't getting any rate of return. And then also there is no significant fixed O&M. So tomorrow's customer was picking up reasonable share of their thing in in the form of fixed O&M, but that is changing now with this new paradigm. So with the new paradigm, we have to think about how to do fair rate making. I don't think it's going to penalize the company. It's more of generation shift. We may have to change some depreciation schedule. That's one simple way to do it, but I don't know whether that will solve that problem. But you can see that after you develop the record. So that's the clarification you ask for it. And one simple thing is a 10O, we have a 210O, so I have to give up my 10O to 10P. And then also if 10O, TUMA 10O is adopted, I have to strike one word from it because there's a repetition of the insurance issue. So I think we can see how we go with that.
Yeah, my inclination, Madam Chair and Commissioner Hom, is to adopt your 10-0 and not do my 10-03. I think yours is more artfully drafted, so that would be my suggestion. Whoever makes the motion to do it that way. And then, Madam Chair, if you're done, Commissioner Hom, to the department and to Xcel on the insurance stuff, I'm glad you're picking that up. One of the things I considered putting in the decision option was to have a more thorough analysis of what is trade secret, but decided not to do it because I think that's something you can do in the course of things. But it was very, very difficult to have a conversation and discussion on that issue because we got it trade secret. And so I'm encouraging you to very carefully look at what really does need to be trade secret in the insurance space. It was all trade secret, and so we were kind of hamstrung there. So just take a careful look at that. I don't make a judgment of it because we just got it that way, but it just made it difficult. So if you just kind of make a very close look at to see, is it really truly trade secret, or did we just lump it all in insurance and call it trade secret? That's what it seemed like. So thank you.
I have a question, Mr. Dobson, about, I just want to make sure I understand the sales forecast and then how it impacts the true up would ultimately work, knowing we haven't approved anything yet. But my understanding is the Rosemont data center will come online in 2026, so the second year of the MYRP, correct?
That's close. That's my recollection. I will admit I have a chart in my head and I can't remember that, but I think that's right. There may be some in 25, but I think you're correct.
Mostly.
Most of it, yeah.
And then, because I think your PALIC direct talked about it, your testimony in there. So this is where I'm pulling it from. But you proposed, or the company has proposed a sales true-up for all the classes, with each individual class being individually trued up. I think that's the way I interpreted it. Does that sound right to you? The proposal is for true-up within individual classes. And for the Rosemont facility, like the commission already approved an electric service agreement, and the department did an analysis showing how that was in the public's interest and why it's a good deal for all of Xcel's customers to have this new data center online and help with overall sales. That's reality. That's not really a question. So I'm curious about how the data center, and once it is online, will then work within the true up that's proposed by the company. And I'm not, what staff and I sort of discussed was like, if the true up then, if the data center comes online and it's trued up within that customer class only for the second year, correct? Like that's the way the true up proposal would work. What happened, and I understand, like, we approved the electric service agreement and later the class cost of service will make decisions in this rate case about, how costs are apportioned, and that will impact all customer classes. But if the data center would be delayed, for example, or not come online when it's anticipated to come online, then the true-up, is there anything we need to be especially looking at, I guess is my question, with relation to the timing of the data center coming online and the sales true-up in this rate case? Because it might be an issue where parties like develop the issue a little more, because first, like the data center is one of the first of its kind in your service territory. It has such a, what appears like a positive impact on overall rates for all customer classes. And if it doesn't come online, then, you know, the true up, if approved, like all those costs would just go to that class of customers. I think that's the way it appears to work. And so,
I'll listen. I apologize.
well, I'm sort of rambling here, but I'm just wondering if there should be any more record development around the issue of the data center, and especially how it relates to the sales true-up proposal and the sales forecast overall. And I don't know if you have any response to that, like those sort of questions, or maybe it's...
My general response is we're happy to develop the record on that. I don't think that I would sit here and give you a very good answer, but happy to make sure that gets discussed. I certainly understand where you're coming from.
I just want, at the end of the when the rate case comes back to us, to all of the parties, I want it to be pretty clear to the commission and to the public the benefit of the data center coming online, and like more, not that we necessarily need more, we don't need to rehash what was already approved in the ESA, for example, but like how the data center growth through the sales true-up and the sales forecast overall will help with downward rate pressure.
Yeah.
Either through the class cost of service decisions or through this sales true-up mechanism.
Yep.
And
maybe the part I'll say, and I think I'd say this is all characterized with of course we can develop further record on this, but I think the two pieces I want to make sure is the fact that the data center is coming online and is part of our sales forecast, just that is lowering the overall revenue requirement for all of our customers because we're having that added sales. But your point I get about then the true up of whether that data center comes in at what it's projected to or above and below, that would then flow, those differences would flow through to that class. But the fact that we're projecting it to come online is benefiting all of the customers. But
yeah, and then what happens if it doesn't come online when it said it's going to? Then, you know, what other things should the parties be looking at and providing, you know, comments on, or Mr. Schultz or Ms. Campbell or Mr. Edstrom, any concern if we add additional language around, you know, the impact of the data centers on new and existing data centers on this rate, in this rate case in general?
No, that's fine, and we're happy to look at that and try to develop that record.
No, we would support that being looked at as well.
Thank you. We would support that as well.
Commissioner Hunt.
Thank you, Chair Siebert. Along the line, I think we recently heard from utility that electrification and data center is requiring us to build a lot of new generation. But meantime, we are hearing that sales is going down for this year. And I think IRA kicked in this year for sure. So I think 100% full year. And I'm wondering, I hope there is a record development on checking an assumption on the electrification and load forecasting, because if that assumption is wrong, output will be wrong. And very anecdotal, I just had a new heat pump. My electricity consumption went up significantly. So that's why electrification has a significant potential impact to residential, small commercial, whoever is taking advantage of it in the heat pump or the EV tax rebate and credit. So I hope there is a good record development on the assumption on that part.
Your gas went down more than
Okay, thank you, Commissioner Hom. Then we're in this list of developing a record on all these issues. And are there any other questions in here that we should kind of work on? Then, what are we on next? 11 is, it is 11, 12, or 13. Sorry, and then any questions from commissioners in there?
No, Madam Chair, I just want to encourage the department. I appreciate hearing that they're going to focus on getting experts in the prepaid pension area. So hopefully they're qualified, good audit kind of background so that we can kind of dig into it deep. So I encourage you and applaud you for spending some time getting that. So thanks.
Can I ask?
Commissioner Sullivan?
I was going to wait until we got to the part about the peak time rebate, but since the expert, the department is also asking for resources for an expert on demand response programs. I'm just wondering why, since I think the SIP unit and the DSM.
Can we wait to get to that in 25, 26, and 27?
Sure.
Or do you want to jump ahead to
No,
that?
it's fine. I just saw it in here, and I was just taking the opportunity to ask a part of that question, but we can wait. That's no problem.
Okay, because I think maybe talking about the, well, maybe it's not, but just the way I was looking at it, like the interim rate deficiency that Xcel is requesting is $223.849 million less the following disallowances. So
It's totally fine. Yeah, we can wait.
On questions around the wildfire mitigation costs, Commissioner Sullivan, Tuma?
I was struggling trying to figure out exactly what the number is, because when I first saw on A2 the 64.3 and the 28.3, I started to panic a little bit, thinking we're going to end up in a similar problem that we had with Minnesota Power. But as I talked to staff and tried to get the understanding of it, it started to make a little bit more sense. So I want to just break down the wildfire first and understand that. If I am reading your attachment 1 to your November 18th filing, this would be what is your proposal for number A1. Then I'm also looking at Mr. Johnson's page 7, where he has table 3. And so I'm trying to make this all meld together. So on O&M, and this is where I'm a little confused, because you have capital and O&M mixed together under the 24.663 or 0.633 million. And so, and as I read this now, what's happening is that revenue requirement is really only the depreciation, which is only a small part of that $60-some million, and your cost of capital. And so that makes sense that yours comes together all in at 24.633. What I don't understand, Ms. Campbell, is I see the 28, okay, which is, about $4 million more of O&M, but I don't have your all-in number because you're in table 2, it's the 64 is what the cost of that's the capital expend, not the cost of capital. And so I don't know if you or Mr. Johnson has your kind of all-in number, which would be O&M plus the cost of the capital that you want out of interim rates for 2025.
I don't believe we do. We did ask for Xcel to provide that in reply, and I don't believe they did, but we can estimate it roughly, obviously for dollar for the expense. So the 28.3 is dollar for dollar.
Right.
And then, like you said, the capital additions, it's usually roughly around 15% of that number. So maybe like $9 million we're talking about roughly. But we also thought that we could do it in a compliance filing, because if the commission decides, yes, they agree with us, they would exclude these capital costs and these O&M, and we would just confirm that that's the right number. So I don't think it's that deal breaker that we don't have the exact number. It's probably like around $38 million, I would guess.
Yeah,
Mr. Dobson.
Madam Chair, Commissioner Tumut, we did calculate it. We can put it in compliance filing. We're looking at, it's actually less because of when the capital is going in.
Right.
But we're calculating a revenue requirement impact from 16A2 of about 31.7. 31.77.
77. So you have yours is 24/7, theirs is 34/7. So we're talking a difference of roughly $7 million difference between what we know as A1 versus A2.
That's correct, but I would make one caveat, which is our proposal would also adopt 17, which is allowing us to defer about 18.
We'll talk about that in a second.
Okay, I just wanted to make sure that was out there.
I want to know the difference then.
Sure.
And that gets me to the question of 17. The term deferred accounting kind of was been thrown around here, and it just seemed to be odd, because my recollection of deferred accounting is that it's a out of test year expense that's unexpected, that's significant, and you come for recovery. Well, the test year is 2025. So you're by definition, you're really not asking for deferred accounting. You're asking that, and I think Ms. Campbell alluded to it a little bit, you're just asking that when we get to final rates, okay, and we find, let's say that your full 31.7 was just and reasonable and a fair cost, okay? We didn't include it in interim rates, but in final rates, 2025, it should have been in there, okay, or could have been in there. We've determined it's in there. It's not deferred accounting. You'll get it in final rates. Now, what you're afraid of is that when we get to final rates, interim rates were unfortunately less than final rates, and therefore you lose out on a portion of that in final rates because of the way interim rates work. And so that's the way I understand it, is that you could be at risk that this $31.7 million is actually going to cause interim rates to be less. Now, Mr. Schultz would argue, probably not likely. That's about 15% to 20, somewhere around 15 to 20% of their request, okay? And usually ask for more of that. So the risk of that, Mr. Schultz, would be highly unlikely. But what you're not asking for deferred counting. You're just asking for protection from the effect of the interim rate statute. That's what I'm seeing. And you can call it deferred accounting because you're protecting your rights, but it really not is traditional deferred accounting as I remember us fighting over it in MP's rate case. So am I wrong, Ms. Campbell? I think that's kind of what you're alluding to, and I think that's an accurate way of saying it. They could still get this $31 million, even though we don't include it in interim rates. It's just going to be something that's calculated out later when we get to final rates.
Ms. Campbell.
Yes, Commissioner Tuma, I believe you're correct that they are concerned that they wouldn't get it during the interim rate period.
We're not denying it. We're just saying this is such an unusual, different thing. We're going to We're going to save it for the rate case to deal with and the testimony and the back and forth about whether it's acceptable. The risk that you're taking and whether we want to let you have that risk is whether it could cause interim rates to be, significantly less than final rates. That's the risk that we're at, right, Mr. Dobson?
Madam Chair, Commissioner Tuma, I think, I get what you're saying, and whether we call it deferred accounting or some other thing, I think you're right. I mean, taking these costs out would push our interim rates down pretty substantially and put us at a greater risk of being in that surcharge position, which means we're going to have to in 2025, account for that as we're going through the year. I think the part I would add to what you're saying is if I'm understanding what you're saying right, is I think that's what A and B, or I think A and B are getting at a little bit of what you're saying, and we would be supportive of 17 with A or B, so that the mechanism doesn't look like what I would think of and what I think you're thinking of as a traditional deferred accounting, but that it to the extent that it can roll into an interim rate refund at the end, then it sort of operates that way.
Yeah, let me understand exactly if that's true, how much we're playing with here, okay? Casino money, okay? We started at the 223, okay? And if we were to do your request, that brings us down to, I think, 199, okay? If we just did your 1A, right? And then, perfectly honest with you, I'm fine with insurance staying in there, but I'll let my other compadres decide. The C, though, my understanding is C is already out of the 223. So really all we're talking about is the 223, and if we don't do insurance, and C's already in there, so we're really only talking about either minus 24.7 or minus 31.7. Am I tracking?
Yes.
So it's a difference between 199 versus 192 as your interim rate amount. Ballpark.
Madam Chair, so that's correct, but the amount, what I'm not following is are we in? That's the difference between 16A1 and 16A2. I agree with you there. I think the question we're talking about, though, is in 17.
I know you want to talk about 17. I just want to know what the number is first before I talk about 17. I want to be convinced I know what that number is compared to what we're risking. That's it.
I think if we the difference between 16A1 and 16A2 is the difference. I think from our perspective, when you incorporate 17, it's whether all of this is gone. Like all of this is out of interim rates, or if in 17, if we have that opportunity to recover those veg management costs to the extent that you find them reasonable.
If they're reasonable, and interim rates is essentially is the 199, and your final rates are 180. You got it.
Yep.
And I think that's the way I see it, Ms. Campbell, is if we get to the end of the game, and for 2025 we got 180, they're going to get those 31.7. That's, you would agree with that, right?
Yes.
So it seemed like it was like, oh, we're in jeopardy of losing it all. You're not. I mean, it's just, it's the risk we take in interim rates. So I think I understand it. I hope I didn't confuse the rest of you, but I had to struggle trying to figure it out because I panicked and I didn't want to have a MP situation like we had in the MP rate case. So I have some other questions on interim rates real quick, Madam Chair, if that's okay.
I think, Commissioner Sullivan needs a break too, so you can ask him if, or Commissioner Sullivan, do you need a break now?
Just a quick break, yeah.
Okay, so why don't we recess until 2:15?
Okay.
the commission will come back from its recess, and we are on to Commissioner Sullivan. Did you have, or
I had a
Commissioner
question.
Tuma, were you
Oh.
done with your?
I have, yeah, one more question on the interim. More of an encouragement. I have no problem with 19. But if we do, and I'm glad Mr. Swanson is here, if we do have a settlement like in, I don't know, November or December, if you could address interim rates in your settlement so that we don't have to come and fight over it when you do your interim rate filing, that would be deeply appreciated.
Madam Chair, Commissioner Tuma, I think that will be in our minds as we're discussing settlement.
Okay.
Yes.
Thank you. No, Commissioner Sullivan, thanks.
I'm glad you mentioned that. I have a question about the 16A1, the 24 million, and that the reduction there. I noticed in reply comments you did not track that into a deferred accounting request. So I'm wondering why shouldn't we just cut it out?
So just to help explain what that is.
Isn't that the O&M?
That number, that 24.663, is the amount that would be reduced from our interim rates.
Right.
A portion of that amount, the 18.1 million in veg management, would be deferred. So that delta, the 24 point minus the 18.1,
6 something,
is now not in interim rates. If we end up with
okay,
the right number, we're not going to be able to collect that.
Okay, I got it. I think.
And if we, to follow up on that, I think, like, I'm thinking about it, Mr. Dobson, as you're proposing these new costs in wildfire mitigation, and the 24 point and change million is their new costs compared to the last rate case, but you're saying that you should be able to defer a chunk of that, which, again, maybe we're rehashing now, but like that's not what we do deferred accounting for. So I'm still having a hard time, like, why not just wait till the conclusion of the rate case and like figure out the overall dollar amount needed for wildfire mitigation that includes vegetation management and those other costs that you say are now incremental and new, and then that's what it is. I think that you're like, it's a little confusing why they're getting why you're asking for deferred accounting in interim rates.
So I guess, Madam Chair, I think to like kind of walk through that, because I get where you're coming from, and I think to start, I mean, our position is that these are the same nature and kind of expenses. We have included, our veg management costs are increasing because of wildfire, but it's a veg management cost, and we have the commission approved veg management in our last rate case. And as you go through all of the costs that sort of make up what we are calling wildfire costs, they are all costs of the nature and kind. There is now a reason for them going up. So that's why I said at the beginning, our primary position has always been 15. What we tried to do was to sort of try to get to some middle ground with parties that said, they obviously disagree. We can lower our interim rates, and remove some of the costs we will remove those. But we think that, particularly distribution and transmission costs are really core utility costs, and so that's what we want to make sure that we are able to continue to recover. And so as part of that, deferring the vegetation management costs was a part of that. So as a way to sort of lower interim rates to get to that spot where parties wanted to go, but also make sure that we're able to recover these costs. That's what this is.
Yeah, I just have it, I'm not going to oppose or not going to support deferred accounting of costs and interim rates. I just think gets us in a big mess, as Commissioner Tuma articulated earlier what happened previously, and like your costs are your costs, and that's what I think should be, you're allowed to request them in your interim rate revenue deficiency amount. So I guess like then your position is just you just put those in the overall costs, and then will be dependent on the parties to get that number down or negotiate it when it comes in front of the commission, hopefully. Ms. Campbell, because I know you don't want deferred accounting either, then just for wildfire mitigation, is there any, if we don't do, your position then still is take out the 64.3 million, and a portion of that is wildfire costs, correct? Just to make sure I'm understanding.
Yes, we believe they're all related to wildfire costs because that's right out of the testimony for the wildfire witness. But some of it's vegetation management embedded in there.
Mm-hmm. Okay, we'll just have to see what other commissioners think about selection of that. But Commissioner
I
Sullivan?
do have another question. Well, I have two, but I'm curious about. So this is, I think about, like, I actually am inclined to say they're of the same nature and kind. So that's just kind of where I'm inclined to think it that way. But when I think of Xcel's infrastructure in Minnesota, explain to me, like, I understand in Colorado why you have forest fire risk and wildfire risk, but in in Minnesota and the Dakotas, you're on the prairie, and the difference between a power line running over cornfields than, through a forest. So can you give me just a little bit more flavor on what you're...
Sure, Madam Chair, Commissioner Sullivan. I think
if it sags to the ground and hits the ground,
sure, I would.
We're not talking about, this is going to be pretty obvious pretty quick.
I would encourage you to take a close look at Ann Sherwood's testimony, who's our Vice President of Wildfire Mitigation, because she addresses this. It's obviously, I don't think it comes naturally to think of Minnesota as a wildfire risk area.
Well,
but
your part of Minnesota, northern Minnesota, I would think is, but
fair. I think, but she actually, in that testimony, she overlays a variety of maps to basically get to where the risk areas are in our service territory. And I think I have it sort of in my head that, there's some higher risk areas in sort of north of the metro, and maybe some other places. But what I think the overall message I would say is, what we're seeing is wildfire risk increasing everywhere. I know that we put in our reply comments, New Jersey, had a wildfire. I don't think anybody would have expected a wildfire in New Jersey. And there actually have been a variety of wildfires in Minnesota. They're not destructive wildfires. They're not sort of out of control destructive wildfires that have happened. But we're continuing to see that risk rise. And it, as I understand it from her testimony, it exists in grassland. Whenever you have dry, windy, conditions, basically if you had a very dry fall, is when your risk goes up. And so actually, to be clear, a lot of our mitigation measures as she goes through them is sort of, there's layers of defenses, and part of that is making sure that during that time in those locations that are particularly ripe for that, we're paying close attention and taking steps. But we're seeing the risk increase. I don't know how Minnesota compares to like Colorado or other areas, but it's a risk that is going up.
Okay. No, that's helpful. Thanks. And then I wanted to ask about if it's okay to move to like decision option 25, 26, and 27.
Yeah, does anybody have any other questions about before those? Oh, maybe we should just talk, well, there's exigent circumstances. Did anyone want to address that? No. Okay, then go ahead, Commissioner Sullivan.
So, my question is for the department, and Ms. Campbell, I know Mr. Fryer is on the line, so this might be for Mr. Fryer, but I think about this, and in reviewing the OAG's comments in the record, and now your change of position, I want to give Mr. Fryer the opportunity to tell me why the department changed its position and tell me how I'm not thinking about this in the most expeditious way. But when I think about peak time rebate, I think about it as demand response, and I think the best way to study that from a programmatic level is through our SIP and ECO program. That it is that SIP ECO is that's kind of the structure that the state has set up specifically to create and deal with programs like this. And so from my default position is that running it through the department's SIP ECO unit is going to be the best way to set up a program. And anybody can, it's noticed and commented, anybody can file comments in that, and that's the way that we should be running these types of programs. When it comes to the impact, the rate impact, just like all DSM programs, they get aggregated up, and then we pay for them in the SIP tracker later. And it's a contained program. The department does what it does best, which is develops the program, has all of the cost effectiveness tests, and works to make sure that the program can work, and that it's got value. It's not just a flash in the pan. Then we then approve the rate as it comes through that SIP tracker filing. Why is that not the way that this should work here?
Sure, thank you for that. I think that's very helpful to explain how that process could work, because I think there definitely were some questions about that. And what we thought was, we have all the parties in this rate case, and there's other issues to be looked at related to those programs and the costs and the impacts of those programs. And we felt like we could look at it more holistically in this rate case, and instead of sort of pre-deciding we're going to do this one thing over here and then we'll do the rest of it over here, we felt like it was better to do it either in that the docket that the commission has, or in the rate case. Sorry, I'm forgetting what the rate design.
Advanced rate design.
Commission investigation, yes. But we thought that the rate case was a good place to do it, and we could hire consultants to help us with it. Anthony provided this to me, and he can certainly add to it, but he said he felt like they had the load management expertise in the context of energy efficiency and program suitability in ECO, but they might not have the in-house expertise on the load management technologies and rate implications. So we would, but like you said, we would probably do the rate implications normally in a miscellaneous filing or in a rate case anyway, right? We would do that part of it. Not the program part would be ECOs. So we certainly could do it the way you want to, Commissioner Sullivan, I guess is the answer, but we felt like if we want all the parties to participate, if we want to look at demand response, peak demand more holistically, it might make more sense to do it in this rate proceeding.
Okay. Is Mr. Fryer, is there, here's what I'm trying to get at is I'd like the most expeditious way to address peak time rebate. I don't want to create a redundant process and take up valuable rate case time on something that could be done in SIP Eco, but I recognize the concerns that the OAG has raised. And I'm ultimately going to defer to what the department wants because, if I just think that this is a program that you're going to have to, put your brain power into. But anyways, Mr. Fryer.
Mr. Fryer, please state your name for the record.
Thank you, Chair Stephen. Anthony Fryer with the Minnesota Department of Commerce. Commissioner Sullivan, we certainly still need more details on the peak time rebate program, and I know Xcel is working on that. But just from what we know at the moment, this is certainly something that, or an approach that has been included in the ECO program in the past by Xcel. The Save a Switch program has this kind of component, so does critical peak pricing program as well. So 25 is certainly a viable option as far as I'm concerned as the director of the ECO program. That said, Ms. Campbell raises some obviously valuable points as well. So in terms of the department, the department preference here, there's a lot of things to consider there, but from the ECO standpoint, it's certainly something that that we can work through. It would take us about 95 days from filing to come out with a decision on the program, which I think would result in a decision around mid-June next year if we had the March 17th filing.
And then, go ahead.
So that's decision option 26. SIP Eco could have. Okay, let me make sure that I understand how decision option 26 would work. That would be filed in the that's the advanced rate making docket 24-320, right? No, that's this docket. 24-115 is the advanced rate making docket.
And can I just clarify? I think 25 is the one that's the ECO one that you're looking for.
Yeah.
And so to me, if I could, it's kind of a weighing of, do you want to do it expeditiously and just focus on the peak time rebate and then have the rest of the load management type programs looked at in the rate case and stuff like that sort of piecemeal? Or is it better to look at it kind of more holistically? And that's a balance, and we will do whatever the commission orders us to do.
Go ahead.
I'm just wondering what the OAG, since you highlighted the issue.
Madam Chair, Commissioner Sullivan, I think our position is that the peak time rebate itself would be a rate, and so it would have to come, if it goes to the department first through ECO, it would have to come back to the commission. We didn't really see the value of parallel processes having testimony filed about peak time rebate or other load flexibility options, but especially if the peak time rebate to have testimony on that in the rate case and then have a parallel process seemed a little redundant to us. But ultimately, we think it's got to be approved by the commission, and so we think optimally having it done in the rate case, it'll expose it to the parties that are going to participate are likely already going to be in the rate case.
How is that different, though?
And Commissioner Sullivan, can I jump in? Because I talked to our staff, and it might be a way to thread the needle between what you're getting at and what I think what you're saying, Commissioner Sullivan, or what you want is for it to be developed, the program to be developed as quickly as possible, and so that the rate impact can be shown in this rate case. Is that? And so what in my briefing with staff, and then what staff came up with, if you could put it on the screen, I understand you have it. The way that our staff recommended another pathway to think about this is having a new docket opened for the peak time rebate program with Xcel filing by March 17th, 2025, which was already the day we told them to file by. And then the docket would say, this is how cost recovery should work, which I presume would mean it could also go through ECO. And then it would fold in the other decisions that are made in that docket in time for it to roll up into this rate case. So I don't know what it's sort of like a conglomeration of these different choices, but it's what our staff came up with that they thought would make sense here, to ensure that it, not to ensure, so it doesn't go into the advanced rate design docket, and then there isn't a decision made in that docket where the program wouldn't be able to be realized in, the benefits of it wouldn't be able to be realized in the rate case, which I think is what you want here. So first, Xcel, if we open a new docket for just the peak time rebate program, like, is that something that you think would work too? And then, so that then it could be incorporated into the rate case? Or would you support this, I guess, first? I'll ask you, and then the other parties. And maybe it's not a solution, but it's what we came up with.
Sure, Madam Chair. I don't think we would have a problem with this. I'll be interested to hear sort of what everybody thinks. I think I'm trying to think through like whether this would achieve. I think we've been sort of operating under, I think, the signal that we got of moving quickly. Mm-hmm. And I'm trying to think through how this would work, because I think we would be filing this on March 17th, but it wouldn't, if I'm understanding it right, I don't think it would be an ECO proposal that we would file. We would have to sort of make a separate filing later based on how we wanted to actually operate the program, which...
Well, I think the point here was like, it says it shall evaluate avenues for cost recovery of the program. So it could include going into the rate case or through ECO, was the way I was understanding what our staff was saying.
Or is it possibly that it'd be a regulatory asset too, or I guess, no.
I mean, I guess that could be an option, but, okay, so you don't know, this might not work, but it was the idea we came up with. Ms. Campbell, do you have or Mr. Fryer, does this help in terms of like, I think my point with staff was we didn't want it to necessarily go into the advanced rate design because those decisions might take a whole long time to get made. And this was trying to like put it on a faster track than that.
Since it's going to have to come back to the rate case, it looks like in your new 27A.
It says possible incorporation into the current rate case.
Okay. I was just wondering if it really is going to be faster that way. And I'm a little, I don't know, I guess I'm a little concerned because I thought I heard that we liked that all the parties were in the rate case, and now we're opening another docket where all the parties will have to participate in it. But we can do it this way if that's the commission's preference.
We could, okay. Commissioner Sullivan, you might not like it, but go ahead.
I don't. I would like to talk to staff for like 5 minutes so that I can hear from where people are. Like, I'm actually not that interested that this shows up in the rate case, because I'm thinking about that if this program works, I just want Xcel ratepayers to get the benefit of it, and they can get the benefit of it through the SIP tracker. It doesn't matter. At the end of the day, it doesn't matter where they get the benefit. I just want them to get the benefit. And if the fastest way to do that is it goes through the SIP tracker, then that's what I'd like. and I don't want to do a bunch of redundant work. And I think that I was listening, to the OHE, and quite frankly, like, I think the argument that you made applies to all DSM programs. Like, they're all rates, and they all get aggregated together, and then they come back to us, and we weigh in on them. So I don't quite understand, like, how that wouldn't apply to every SIP program. So, and maybe I'm just getting annoyed because I woke up on the wrong side of the bed, but I just want to...
It's the joy of serving with you on this dais, Commissioner Sullivan. I'm not trying to take over your issue, but I'll just say a few things that staff said. Sometimes not all parties participate in the rate case, and so pulling it out of the rate case would allow the other parties to be able to weigh in here. But we can add language into this that says it should evaluate, incorporate it into ECO or into the rate case. Like, I'm not trying to do anything you don't want here. We were trying to just streamline things and make it easier for everyone to participate.
If I understand right.
And it's not worth, like, getting upset about. It's just the way we'll just figure it out. We can take a break and...
I've been trying to get my head around it too, but so let me just ask a question if I could. If we do it in ECO, it gets done, it's getting tracked, but then the rate case could still pick it up later and deal with it as a rate too, and we can convert it into a more of a rate, part of our rate structure and take it out of ECO. Is that? But OAG, you're the one that's having concern with it, so that's the way I see it. And maybe I'm wrong.
Madam
Mr.
Chair,
Schultz.
I think we have some concerns about if the commission wants it to come back to the rate case, how that would work, because it has to be brought before OAH somehow. It has to be sponsored by a witness for it to be considered as part of the rate case, so to speak. I think that's our concern with that sort of procedural jump. That was what I wanted to say.
Commissioner Hahn.
Thank you, Chair Sieben. So this is a peak rebate. So that means it will have an impact to the peak demand of the class. So it will have a potential impact to CCOSS. It will have a potential impact to MISO wholesale capacity sales revenue calculation. And then also under the new MISO RBDC, reliability-based demand curve construct, it can have a potential impact to overall Xcel's capacity requirements. So there are several items. It has a potential impact to the ratepayers right away. So I'm not taking any one position or another in this wrong, but unless we are potentially reflecting this one, not only the expense of the administering this cost, benefit has to be reflected in this rate case. Otherwise, ratepayers are paying for the cost but not capturing the benefit of it. So I hope we need to consider that there are multiple moving parts under this proposal because this one is intent to bring down the peak for the class.
Okay, well, why don't we take a break, and Commissioner Sullivan, you can talk to staff then and see if you can come up with something you're comfortable with, if that's what you want to do.
And I also just want to reiterate, I'm not really annoyed at anybody in particular. I'm annoyed at myself that I can't articulate it. So.
Okay, how much time do you need?
5 minutes.
The commission will recess until 2:50. commission will come back from its recess, and I'll call on Commissioner Sullivan to kick us off.
Okay. I have talked to staff, and I am convinced now that I don't see it in here, but that the decision option 27A.
Did you say I was right?
I was actually, that's funny you said that. Okay, now.
Don't push it. We were getting there. Little turbulence.
That's funny.
She needs to sit between us.
That's scary.
Yeah. So I understand. So 27A. I'm okay.
And do you want to hear if, Mr. McAllister, can you put that on the screen? Except it's Mr. Blodgett, actually.
Nice job.
Name change.
I'll explain later why I mixed those names up. But anyway, I do know two Jamies, so there you go. Sorry about that. Okay. Do you want to hear from parties if they're okay with
No.
staff's decision option?
No. Wise choice.
Okay. And then before, I think I'm ready, or I can start with a motion if commissioners are ready. And what I would propose is I'll not make a motion related to wildfire expense, and then we can pull that out separately, if that sounds okay, unless any other commissioner wants to make a motion overall. No? Okay, so then I'm working off of the decision option list. First, I would move decision option 1 to accept the petition. Number 7, which is the later date. Number 9, and I'll add new language granting Cub's request to be, or I would grant Cub's motion to intervene in the proceeding as well. Number 10, with an addition that says the standard rate case issues, including the impact of data centers, to reflect the conversation earlier. Then B through H, and then I need to pause to ask if we still want I, if we're doing the peak time rebate proposal in another docket.
What is that language called? Mr. Blodgett,
And maybe I'll first ask Ms. Campbell if you have a suggestion about that. So, because I think if we're doing the new 27A language, those, do you still want I included in here, or do you think it would be covered in the other docket and then it will roll into the rate case anyway? So you it might be redundant, but just, Ms. Campbell, your thoughts on that?
I think it'll be, depending on the timing, it might be difficult to do that. And it, like you said, it might occur on the other dockets. Might be something that once that's approved, we would have to look at in a future rate proceeding.
Okay, so then let's just, I'd again move 10, A through H, and then skip to J through, what's the last one here? M, as written, and then we need to add, and N. I'd included my motion. And then we have Tuma's new 10O, but instead of 3 on Tuma's, we would replace Commissioner Ham's new language there, correct? And then in my motion, Mr. Blodgett, if I'm going too fast, tell me. Or good?
I just cluttered with shared topics.
Sure. So just to back up on 10, it was mostly the same, but we took out I and then modified the data center thing in A, and then took Tuma and Ham's new language in O. Good. And then 11,
Including A, I assume.
yes. A included 12, 13. We'll skip over this section and then go to 19, 21, 22, 24, staff's new, what number was it?
27A.
27A. Notice I didn't call it mine, 27A.
It was implied.
28 through 31. So I think, commissioners, that part, it's not everything, remember, we still have to do the interim rate deficiency amount, but that would be my motion for right now. Is there any discussion or concerns we missed anything? Then all in favor of my motion, please say aye.
Aye.
The motion prevails. So now, commissioners, someone else can make a motion on the interim rate revenue deficiency. Like, I think it's somewhat tricky, and there are good arguments on various sides. So, who would like to make a motion?
Madam Chair, I'm comfortable with 16A2 as the only motion in this here, because B and C would be, well, C is already in the final number. We're talking only somewhere in the neighborhood about 15% reduction when you take into account that it's not $64.3 million, it's somewhere in the neighborhood of $7 million or something like that. I can't remember it. It's not as big as that number, so that's where I get comfortable with it when we're talking more like a number of 31.7, so all in. So I'm comfortable with 16A2 and not doing 17 because I don't think we have to do it. It'll be taken care of in final rates.
Does anyone have any comments on Commissioner Tuma's motion to move 16A2? Commissioner Sullivan?
I mean, Commissioner Tooman, we don't need to rehash everything, but I mean, my sense is that many of these costs are, I mean, very similar and like in kind. I don't know why we would do, I mean, I'm just kind of concerned. And
I guess my only, my argument is, or my position is that the company could have broke that down. They did in their filings, in their testimony. They drop it in a late filing on the 18th. Doesn't give the parties the time and ability. They're big folks. They've been doing this for years. They could have broke it down in the original filing, and so, and given the fact that it really doesn't put them at really, I think, any significant risk, it's a pretty minor risk that it puts them at, I'm just more comfortable, and you know me, if I can have a little less interim rates that aren't going to give me the MP problem that we had, I would lean that way. I'm not going to, I mean, if you feel more comfortable with 24, like A1, but not do 17, I don't think I would be bothered by that either. We're talking a difference of $7 million in interim rates.
And Commissioner Tuma, like to your point, I think the company could still make the case that they need this additional revenue. They just need to make it in the rate case proceeding. So it's not like we're saying they can't recover these costs ever. It's just for right now. So I guess from that perspective, I'm comfortable with that as well because, as you said, they weren't the same types of costs that were approved in the most recent rate case either.
It was hard to judge that, and they can make that argument now, but again, I always fall back on when they're in doubt, you fall on the side of the ratepayer.
Commissioner Hom, thoughts?
Yeah, I was a split between 15 and, as you say, 16A2, because I do not want that Xcel is not doing these things. So I was debating, but Chair just made a case for me. Yes, because we are denying the interim rate doesn't mean that Xcel doesn't need to cancel this project and they can keep doing it and then make their case in the rate case. So that's why now I'm more comfortable agreeing with you on this.
With Commissioner Tuma?
Yes.
And then that, I don't remember if did I put 19 in my last motion?
Yes, you did.
I did. So we already made the decision to defer the 2026, the second year. Okay. Commissioner Means, any thoughts on this topic?
No, Chair. I landed at Commissioner Tuma's motion about an hour ago. Thanks.
You're quicker
6
than
years
me,
ago,
that's
maybe?
for sure. Okay. Then Commissioner Tuma moves 16A2. All those in favor, please say aye.
Aye.
Aye. Opposed? The motion prevails. Anything else we missed here? Commissioners or parties? Okay. With that, then, thank you, everyone, for your extensive work today on this. We appreciate it, and hope that everybody has a good afternoon. The commission is adjourned.